May I please, your lordship? Yes. Lordship, I beg to mention item number 44 and 7. Lordship, my senior is sick since midnight. Severely sick he is.
Item number 7.
7 and 44.
Other side,
In
the other
40,
side.
Lordship,
I am there in 44, my lord. In item 44, I am appearing, lords, for the.
Yes, Mr. Nair. So,
No, but that makes some personal difficulty. Some personal
mention is
difficulty, I
ground.
can't say anything.
Is it
My friend
okay
is
if
in
we
some
adjourn the
personal-
matter?
Very well, lords. It could be, if it could be next week, subject to your lordship's convenience, my lord.
Next week would virtually be all holidays.
Then
So
the
we'll
week
have
after,
to-
the
We'll
week
have to
after,
post it in the week beginning from 20th March.
whatever's convenient to the court. my lord.
You give out a suitable date.
Lordship may, whatever's convenient, bro. Lordship may have it on 21st or 22nd, lords, whatever is convenient.
Okay. A request is made to adjourn the matter on behalf of the appellant.
Lordship on respondent.
No, respondent, my lord. I'm for the-
Respondent.
We are from the respondent.
UGC.
On behalf of the respondents, on the ground that learned counsel leading the matter is indisposed as prayed list on 21st of March.
Very grateful.
Item number 7
Yes, lordship.
and same in item number 44.
44.
Who is taken ill?
Lordship?
Council UTC.
Standing counsel UGC.
Yes, lordship.
Very well.
I am for the respondent in item number 7, my lord. A date will be given.
Date 22nd कर दीजिएगा, एक में 21st और एक में 22nd.
I'm deeply obliged.
May I please, your lordship? I beg to mention item number 55 of the daily list. With
Yes.
consent of the opposite party, I pray for an adjournment in this matter, my lord.
55.
Yes, my lord.
What do you want, adjournment, ma'am?
My lord, the file has been misplaced.
File has been misplaced. Oh, what a pathetic kind of excuse is that?
Well, just we just need a short date.
Counsel for the respondent pays for time to
My lord,
reconstruct
appellant.
appellant. To reconstruct the file as prayed. The other side? No one on the other side. Do you have any objection?
No, lordship.
As prayed list on 28th March, 29th March,
Obliged.
28th would be a hearing day. Yes.
May it please your lordship, I beg to mention for listing, my lord, on Thursday, my lord, there's an urgency in this matter. As by the London single judge judgment, our seniority has been affected and a tradition list will come up soon. And whereas
What is the date of the single bench judgment, please?
8th of February, my lord, we filed it on 20th of February itself. But still it has not been listed, my lord.
You want it to be listed on
Second, my lord,
second.
my lord.
Very well.
My lord.
Get it listed on second.
Much obliged, my
May
lord.
it please, your lordship, I beg to mention item number 53. Due to some inconvenience on part of the engaged counsel, senior advocate Mr. Kian Chaudhary, the matter may be adjourned for the day, your lordship. I'm from the appellant.
53 or 43?
53, your lordship.
53. The other side,
We have taken consent from the other side.
you
your
have not
lordship.
submitted an adjournment slip, madam. These are hearing matters.
Yes, your lordship.
Very well.
Yes, your lordship.
As prayed by learned counsel representing the respondents,
Appellant, your lordship.
appellant. List on 30th March.
Much obliged.
May I please, your lordship? Lordship, I am praying for a listing, lordship, a rate petition, lordship. Regarding the habeas corpus matter, lordship, 2nd March, lordship.
2nd March.
Yes.
It's a fresh matter.
Fresh matter, lordship. It was filed on 22, lordship.
Okay, get it listed. Why are habeas corpus petitions taking so long for this thing? Habeas corpus petitions are supposed to be listed either on the next day or the day after. Instruct the rest.
If you may please, my
Obliged.
lordship.
Any matter
May
pertaining
I
to
please,
detention.
lordship, I am
Has to be listed
on
fast.
behalf of peaceful lordship. I'm praying for urgent listing. Only the source of income business of the petitioner is only the source of income. Kindly give a sorted matter.
What is the matter about?
Tax matter, GST matter,
Tax matter.
my lord.
Get it listed on second very well.
If you may-
Obliged, my lord.
if you may please, my lord, it is for urgent listing. I'm a 73-year-old male in Dibrugarh jail right now. I'm suffering from dysphagia. I have severe disc lesions.
What have you filed? What have you filed?
It's a criminal appeal and a bail matter. It regard to
Why
section-
is it supposed to come up before this court?
because my lordship, I mean, I have a health condition right now. I cannot
That
digest.
is all right, but the the bench hearing criminal matters is probably division bench number 3.
Yes, my lord.
So you have to make a mention there.
Okay.
Go and make a mention there.
Lordship, I beg to mention a writ appeal number 225 of 2022. The matter was last posted on 24/01/2023. And the order, it has supposed to come within 3 weeks and government is supposed to pay certain amount to the petitioner. So kindly list the matter on that.
Well, you get it listed in the week beginning from 13th March. Okay,
Okay. If possible, sir, 0 on Friday next week.
not possible. Friday, it will be difficulty. Get it listed on 15th March.
Item number 1 to 5 of daily list.
If it may please this honorable court.
Yes,
Because these are 5 habeas corpus matters.
habeas corpus.
Indeed.
And why adjournment slips have been circulated?
Lords, there's one issue. Because I'd like to address this honorable court regarding certain developments which have taken place this month. My lords, I'm aware of the adjournment slip. I'll
Habeas
justify.
corpus, in what kind of detention?
My lords, the petitioners are representing declared foreign nationals and convicted foreign nationals
Okay,
who have been detained in 5 central and district jails, which have been declared as temporary prisons, my lords,
Mhm.
as temporary detention centers
right.
in 6 districts. There's 6 jails, my lords. These 6 districts are Gwalpara, Jorhat, Dibrugarh, Tejpur, Kokrajhar, and Silchar, my lords.
Mhm.
At the time when these petitions were instituted, my lords, the individuals whom the petitioners were representing were lodged in 2 jails. These were in Jorhat and in Gwalpara, my lords. The first writ petition before this honorable court pertains to 5 female declared foreign nationals in Jorhat jail. The rest pertain to people who are lodged in the Gwalpara temporary jail, my lords.
Right.
Now, my lords, the issue that came up before this honorable court was that in 2012, there was a judgment passed by the Honorable Apex Court, my lords, in Bhim Singh, which is 2012 13 SAC 471.
Mhm.
In this, the Honorable Supreme Court held that foreign nationals who are detained, they cannot be kept in jails, my lords. They have to be lodged in detention
Detention
centers,
centers.
which are outside jails, my lords. Now, after this, there were 3 letters in 2012,
If they were convicted,
yes,
why
my lords,
can't
even
they
if
be
they're
kept in
convicted.
jail?
And even for declared,
Declared.
yes, even for declared foreign nationals, my lords. Yes.
Which declares the person. Nationality. Yeah. Okay. Right. Mhm. Right. Right. That is there. The custody at the detention center can't be in prison. Right. Detention. Declared to be. Mhm. We dealt with some person from Nigeria who was detained in a detention center at Alwar. This is ultimately the call of the central government to accept or build over the infrastructure. Okay. Right. It's in a good condition.
29th of November, my lords,
Hmm.
was the last effective date.
They all pitched here. Sort of expect for the right. Once the funding is there, they have to be self-replacing. Either they have to be deported or. That is Basically, it's tradition. Yeah. People talk about it. Explain. With the remedy, against your opinion. There's a contradiction. Yeah. So his case is that they can't. Yes.
Yes, Milords, as my Lordship Justice Saike has apprises on court, because on 17th of November, there's an order of last year. And my Lord Justice Saike was a part of that bench with the former Chief Justice Milords. And they had visited the Matia Center, Milords. Now, Matia, Milords, there's a certain history to Matia, Milords. There are certain dates which I would like to point out to this Honorable Court, Milords. The first affidavit that was filed by respondent number 3 was 12th of June 2020, wherein they say that a permanent detention center is going to be set up at Matia. Then an order comes to be passed by this Honorable Court on 7th of October 2020, wherein this Honorable Court very specifically, Milords, held that these prisoners, these individuals, they cannot be kept in any jail, Milords. They have to be housed outside jails at any cost, even if it is in temporary accommodations arranged by the government. 21st of December 2020, for the first time, a compliance affidavit is filed by the government, Milords, wherein the government says that Matia will be completed very soon. After that, Milord, 11th of August 2021, the government makes a statement that we need 45 days for Matia to be operational. This is 2021, Milords, 11th of August. 45 days pass. We come to 11th of February 2022. The government says that the construction at Matia is complete and it will be operational. Only we need some security personnel, some manpower needs to be arranged, and that's all. The government also makes a submission there, Milords, on 11th of February 2022, that once Matia is operational, all the grievances of the petitioners will be completely redressed.
What is the capacity of that Matia facility?
3,000, Milords, 1,500 plus 1,500.
Okay.
1,500 men, 1,500 females.
Right.
Their stand has consistently been, Milords, that once Matia is made operational, all our grievances will be redressed. Our stand is that some antecedent illegalities will still remain. But they were saying that the model manual of 2019 for detention centers, as released by the Ministry of Home Affairs, central government, that has been complied with as far as Matia is concerned. 2 affidavits were filed last year, Milords, 9th of March 2022, and then on 30th of August 2022, where they said that Matia construction is not complete. Very well, Milords. After that, last year, on 17th of November, Milords, an order comes to be passed by this Honorable Court, where it was observed that your lordships had gone there, this Honorable Bench had gone to Matia, and they had observed that it is ready for habitation, and some emergency measures may be taken for temporary people to be posted there so that it can be made operational. On 29th of November, which is the last effective order of this Honorable Court, the government takes a stand that they've taken a conscious decision to make Matia operational. And now, after that, Milords, this is where I join issue, Milords. Now, presently for today's hearing, Milords, there's an affidavit that I have filed yesterday, Milords, in writ petition number 6, which is item number 4 before your lordships today. Abanti Datta, Milords. Milords will kindly come to that affidavit for a moment, Milords, if I may kindly invite this bench to this affidavit. Page 155, running page number 155 and extra B. If I may read, Milords.
Yes, please.
In exercise of powers conferred by Section 3, subsection 2 of the Assam Prison Act, the governor of Assam is pleased to notify a part of the transit camp Matia comprising of 8 blocks as temporary jail until further order. Now, Millers, the baby gets thrown out with the bathwater. All the bona fides that they have demonstrated till date is completely set to naught. The Matia transit camp has also now become a jail. So essentially, they are now housing foreign nationals, DFNs and CFNs, along with citizens who are criminals. The entire premise which they set up via an affidavit on 12th of June 2020, Millers, 3 years ago almost, that Matia will be something completely different than these 6 central jails, whose operation, whose setting up we were impugning.
And why they are trying to categorize it as a prison? They don't have enough
We are unaware.
space in the prisons?
We are unaware, Millers. We only got
Where
hold
is
of this
that?
notification
Look at
recently,
that,
Millers.
please.
I do not have any instructions regarding why they did this.
Where is the Advocate General?
Instructed the Mafia transit camp that has been paid for. I have paid that since 27/1/2020.
But what learned counsel says that you also declared it to be a temporary jail. How can that be? And what is the justification? You would like to have the assistance of learned Advocate General, please. Please call him. We are passing it over. You have placed this on affidavit
Indeed, Millers.
with the
Yes,
communication.
yes.
Any
No, Millers. It's an order. It's an order issued by the government of Assam, Millers. It's a notification
Call
by
the affidavit. Call the affidavit. Yes. So, Mr. Counsel,
Millers.
assuming that we are able to ensure that Matia retains its character as a detention center for foreigners, your issues will be resolved.
Millers, in my humble submission, they will not be entirely. Millers. There are certain antecedent illegalities which we were addressing in
All
the
right.
habeas corpus.
We'll
Millers.
we'll
Very well.
hear them. One,
Very
let learned Advocate General, please.
Very well.
Yes. Pass over.
Item number 6 of daily list.
May I please look. See, this appeal was filed by the Revenue Department. But see, recently, Honorable Supreme Court in 2022 held that the appeal will lie within the jurisdiction where the assessment order has been passed. In this case, assessment order was filed by the executive officer at Shillong, Lordship.
Otherwise also, sir, this is only a remand. Why do you want to come and read page 45? Other than the fact that it is not in the correct jurisdiction,
Lordship.
read page 45.
We have viewed that
The ITAT has just remanded the matter back.
go to the receiver.
Why do you want to challenge this order? It's back in your court to decide.
Not
Withdraw it, get the matter re-examined on remand. What is the problem?
that is there, but Lordship recently Supreme Court held that the appeal will lie to the concerned High Court. Where the assessing officer
Rather
was
than
filed.
returning it, you
No.
can simply carry on with the excise post remand.
That can be also.
All right. No. End of order. Exemption was claimed for the tribunal. That is the remand is for. So it is remanded to the court. We are therefore of the view. So remand was-
Motion was remanded, Your Lordship.
So you want a return of the written petition to be filed before appropriate forum? Very well.
Lordship make paragraph 45 of this.
ABC.
ABC
Yes,
papers.
ABC
ABC
papers.
papers.
Paragraph 45.
Page 25, Your Honor.
I heard Mr. S.C. Kial, learned counsel appearing for the appellant,
Not-
Income Tax Department, and Mr. Sharma,
Lordship.
PK. Sharma appearing for the SSC respondent. This appeal is directed under 260 capital A of the Income Tax Act against the order passed, order dated so and so passed by the IT Income Tax Appellate Tribunal, Kolkata. posted. During the pendency of the appeal, a judgment came to be rendered by the Apex Court in Principal Commissioner of Income Tax 1 Chandigarh versus ABC Papers Limited, civil appeal number so and so, wherein the Apex Court rendered a finding that appeals under Section 260 capital A of the Income Tax Act shall lie in the High Court, in whose jurisdiction the assessing officers are situated. In the present case, the assessing officer, the office of the assessing officer is in Shillong, Meghalaya. Therefore, the learned counsel for the appellant submits that in view of the findings of the Apex Court rendered in so and so ABC Papers Supra, he does not wish to press this appeal, with a liberty to file afresh if so advised before the appropriate forum. Para, in view of such submissions, the appeal is dismissed on withdrawal. However, liberty is granted to file before the appropriate forum if so advised.
Office may be directed to return the memo of appeal along with the certificate of appeal.
The you want to withdraw registry. Registry will retain a copy and return the memo of appeal, permitting him to file it before the appropriate forum. Okay. Disposed as under.
Item number 8.
May it please your lordship. This is an appeal against the order of the single judge. Well, the factual matrix is that I got a contract and the respondent number 6 challenged it on the ground that for a particular financial year, I did not give my financial statement, but he quoted a section which was not relevant vis-a-vis my case. And the learned single judge took a view that it's a mandatory requirement and I lost the case. Well, the contention, lordship, on one ground, my appeal stands. Lordship will come to page 96 of my appeal. Lordship will find the terms of 4.3 down below. If I can read, Lordship.
Yes.
If the employer has not undertaken pre-qualification of potential bidders, all bidders shall furnish the following information and documents. Lordship at page 96.
Yes.
4.3. Yes. If the employer has not undertaken pre-qualification of potential bidders, all bidders shall furnish the following information and documents with their bids in section 2. My lord, your lordship will now come to page 113. This is section 2. The operative part is page 114. If I may read, Lord. 1.2. Page 114, 1.2.
Yes.
The total volume of civil engineering construction work for the 5 years, my lord, this 5 years specified is 14 to 19. I specify, I comply. They take section 1 and they say that 20 was absolutely irrelevant. The learned single judge took a view. In this case, my lord, there were no allegation of malefits or infraction of rules.
5 years.
Yes, and in fact, I am directly covered by a Supreme Court judgment of 2013.
First, satisfies
Yes.
facts, please.
Yes, Lordship.
Yes.
Your Lordship will find page 110 was their contention.
Just please come to 4.3.f.
Yes.
Past 5 years. Now, what does this past 5 years mean?
My lord, if I may read 4.5a.
Yes.
To qualify for award of the contract, each bidder in the manner should have in the last 5 years, as referred to in the appendix, achieve a minimum financial turnover in all classes of civil engineering, construction works only of 60% of the estimated cost of the package. For works of value up to 200 lakhs and 75% of the estimated cost of the package. For works of the value more than 200 lakhs, cost of completed works of previous year shall be given weightage of 10% per year based on rupee value to bring them to present price value in any one year. And my financial,
You are reading from which page?
I'm reading page 97, Lord.
97.
Page 97,
4.3 B.
4.5B.
4.5B. Okay.
I have my paragraph is 4.5A.
Yes.
Because our contention was a conjoint reading was necessary, that was
Yes.
not done. So in any 1 year that was required. Their contention is that you did not give for the financial year 1920.
So they are going by past 5 years. Meaning
Yes.
past 5 years, just preceding the year of the NIT. That's what they are referring to.
They refer to 110 on which I will show that it refers to section 1, which is not at all relevant. Lordship may come to page 110.
Yes.
Appendix to ITBC. Appendix to ITBC, one clause reference with respect to section 1. 2, the last 5 years furnish the following information required of the following financial year 15 to 20.
Right.
So on the premise, the learned single judge took a view and basically my.
You did not have the information regarding 2019.
Yes, because in fact, assuming that I took the contention also, if it was considered nil also, since I had a better financial turnover than the other person. And the second very important ground is that the government, free play in the joints is a decision rendered in the Tata Cellular. In contractual matters, the courts, a limited scope and wide latitude is given to government, because if the government is not given the latitude, they won't be able to. And the petitioner could not bring
How do
any
you
case.
reconcile this to this qualification information on page 114 and the discrepancy, apparent discrepancy at page 1110?
My contention.
Because there the years are given from 15 to 20. Here this is 14 to 19.
Yes. Because 4.3 says section 2. From where section 1 comes, that is there, they have not been able to show. I specifically point out 2 talks about 19 and I comply with it.
2, section 2, right?
Yes.
And section 1 starts from page 109.
Yes, 109.
Oh,
So this.
Where is precisely section 1 where it starts?
Yes. Section 1, in fact, could not. Because it was on this section 1, which the respondent number 6 took the plea and the
Section 1 starts from 94.
Yes.
Instructions to bidders.
Yes.
So section 1 is inclusive of section 2 as a matter of fact.
Well, 1 is for instructions. Because a specific 4.3 talks about section 2 and section 2 talks about 19, financial year 19.
Yes. Past 5 years. Past 5 years. Would it have to be referred? Then the last 5 years in accordance with section.
Yes.
Because the titles.
Well, then it comes to section 4.3F.
Preceding the date of the NIT.
Past year's question.
Then they have qualified it. Documents with their bids, section 2. So section 2 is referring to the last 5 years. This refers to
114.
114.
114.
14 to 19. There is some anomaly. There is a discrepancy in that case. That is the government.
It would have mentioned it, no? In fact, 4.3, Lordship.
114.
The additional point I can take, 4.3F, your Lordship will find.
Yes.
Reports on the page 97. Reports on the financial standing of the bidder, such a profit and loss statement and auditor's report for the past 5 years. They never specify that it has to be 20 till 20.
That is
So
presumed past 5 years in reference to the date of NIT.
Yes, and
so that would come, the 20 would be included in that.
yes, but the
Plain
fact
language.
that section
But
2
yes,
comes in.
Yes, section 2 you are referring That is something to be,
4.3
Considered.
clause. Yes, that's my case.
again, sir, 122. उसमें भी 19 तक ही है. And then again, a discrepancy below that. 1920. This is converse. You see. 1.0 says
Is
the information required for financial years. 115 says engineering construction work. And 122 turnover till 19 and civil construction work till
In fact, page 121, I further state that the information, the qualification information 4.3, 121 also talks about the financial turnover at page 122 till 19.
till 19.
Yes.
But the civil engineering construction work performed, that date is again referred to as 20.
Financial statement is not correct. That is on the certificate of an engineer.
Well, there the financial statement is not required. The certificate of an engineer is required.
Engineers.
That also we have supplied. So we have complied with it.
Yes.
And on a
Yes.
on a similar set of facts, if I can place, the Supreme Court says at most it's a curable defect. It could have been done. In my case, that was not done. And the Supreme Court allowed the appeal on similar facts. I've given the judgment. It's absolutely on the same ground. There also 5-year statement was not given. The Supreme Court allowed the appeal. But the operative paragraph will be at 14 to 15. 17 to 19 will be the operative part.
17, there's no para. The
Malad,
judgment ends at
17 to
14.
18. Malad, if I may read the paragraph 18,
अच्छा, इन्होंने मुझे ये print out.
if I may read, Lord.
Yes.
We think that the income tax returns could have assumed the character of an essential term if one of the qualification was either the gross income or the net income. Lordship, can I read?
Yes, yes.
On which tax was attracted. In many cases, this is a salutary stipulations since it is indicative of the commercial standing and reliability of the tendering entity. This feature being extant, we think that the filing of the latest income tax return was a collateral term, and accordingly, the tendering authority ought to have brought this discrepancy to the notice of the appellant. And even if thereafter no rectification has been carried out, the position may have been appreciably different. It has been asserted on behalf of the appellant company and not denied by the learned counsel for the respondent authority. Financial bid of the appellant company is a
This
substantial.
fact is different.
Yes.
Lower bid.
Yes.
That is a,
But
because
ours
your
was
bids
similar.
are on the same level.
Yes. Here the bids were, and one point which was taken by the government supported us, that our past performance was such, that was a relevant consideration which the government took and awarded us.
Right.
So that's my summation.
Let's hear them. Yes, please.
May it please the Lordship. Your Lordship will kindly turn to page 96.
Yes, please.
The eligible bidders, Your Lordship.
Yes.
Section 3, Your Lordship, clause 3, I'm sorry, Your Lordship.
4.3.
It's 3, Your Lordship, page 96.
Yes.
Eligible bidders, 3.2. All bidders shall provide in section 2 forms of bid and qualification information, a statement that the bidder is neither associated or has been associated. Now I'll pause here for a moment. They have sought all the qualifications and all the documents and the requirements as per section 2. Now section 2 is at page 112, Your Lordship. It starts at page 113, Your Lordship.
Yes.
Yes, Your Lordship, it starts at section 2. Qualification 1.3.2 at 115, Your Lordship. Quantities of the work executed as prime contractor
work performed in the past as nominated subcontractor will also be considered provided subcontract involved. Here it is still 2019 and 20, your lordship. And as your lordship has rightly pointed out, the
Where are you
date of
reading?
page 115, your lordship of the.
115.
Yes, it's still 2019 and 20. And as your lordship has rightly pointed out, that the past 5 years would mean the date of the issuance of the NIT. So NIT was issued on 21/12/2020. That the financial year would end on 31/3/2020. It is he and one of the bidder who has not submitted that financial bid, your lordship. So, and accordingly, in spite of that, that was awarded to him. So the learned single judge has come to the conclusion that was the right finding, that he should have submitted the bid, but he has not submitted that bid, your lordship.
He has submitted the bid, but not compliant as per you
Yes, your lordship.
regarding the financial year 2019-20.
Yes, your lordship.
Financial bid, of course, he has submitted. Your and his financial bid are at par.
No, I want to say, I'm sorry, your lordship. Your lordship is right, your lordship. The audited balance sheet for the year 2019 and 20.
2019-20 is not submitted.
In fact, page 109 clause 2.e is very clear, your lordship. If your lordship kindly peruse 109 2e. I'll see clause 2. Registration certificate, copy of the PAN card, professional clearance, power of attorney. 2 is important, your lordship. Audited balance sheet signed by qualified CA for the last 5 years showing amount received from civil contract. Now, if your lordship.
Maybe. State. Now 3 years down the line, this quarrel is going on between two parties, two bidders. Why don't you think of floating a fresh one?
That can be definitely done, lordship. That is not a difficult situation. But the thing is that the work will get further delayed. That is the only concern because.
What do you think that if you decide the list here, they will not go to the Supreme Court?
Hopefully not, lordship. We always think positive.
You should have been hopeful after the single bench judgment also.
We did not prefer the appeal.
You did not. You were supporting the respondent all along. You had accepted his bid.
We have accepted because there is a clause which has not been placed before this honorable court. Because the learned single just considered that clause as mandatory, but whether that is mandatory or not, that is the issue. 4.3.
But we are asking you, Mrs. Saikia,
lordship,
that now this is 3 years down the line.
Lordship.
Probably you will get a better bid now.
There will be escalation, lordship.
Escalation, yes.
There will be escalation, but we are getting this at the old rate.
Okay. You're right.
Here, lordship, 4.5.a, lordship. That is why
4.5.a. Yes.
This says because they are only harping upon F. 4.3.f, which says report of the financial standing of the bidder, such as profit and loss making statement and auditor reports for last 5 years. So 5 years we are asking, but whether 5 years is required or not, because we have to qualify this with.
If it is not required, why do you mention it in the tender document?
We have said.
Then you should have clarity in the documents.
But that is why the discretion lies with the employer, lordship, because 4.5.a says to qualify for award of the contract, each bidder in its name should have in the last 5 years as referred to in appendix achieved a minimum annual financial turnover in all classes of civil engineering construction works of 60% of the estimated cost of the package for work of the value up to 200 lakhs and 75% of the estimate cost of the package for the work of value of more than 200 lakhs, etc., etc. Cost of completed work of previous year shall be given weightage of 10% based on rupee value to bring them to present price in any 1 year. So basically what we are trying that in any 1 year, if he qualifies, then these 5 years things we will consider, but out of those 5 years, only 1 year will be considered. So he has given 4. And if we look at clause 31, of the same award of contract.
Yes.
31 says, Lordship,
That is regarding
31 says,
pricing.
31 Roman 1 says, award criteria subject to clause 32, the employer will award the contract to the bidder whose bid has been determined. Roman 1, to be substantially responsive to the bidding document and who have offered the lowest evaluated bid price.
There-
So
there is no question
substantially
of lowest.
responsive.
They are not exclusive of each other. They are inclusive. Both have to be compliant. And who has offered the lowest
Yes,
evaluated bid
now
price.
if we look at the word substantially responsive. So when they have given 4 out of 5 and we are considering only 1 year out of those 5,
Both were substantially responsible.
they are substantially responsive.
Both were there.
Yes.
So for excluding the
Yes, for excluding, we in our affidavit, because the learned single just finally said, what is our criteria? For that, in our affidavit, we have put a very specific affidavit that is a part of the record
let us see that.
at page 316. The affidavit in opposition filed by Sanjeev Shyam,
316.
316. Yes, 316.
Yes.
Here we have said, very categorically, if Lordship is pleased to look at the chart, abstract chart at page 326.
Yes.
Pavitra Boru and Bhabadev Mohanta. Bhabadev Mohanta, it is the private respondent here.
Yes.
Works completed 100%. Pavitra Boru completed 24 number of works. Bhabadev 13 number of works. Works above 9 crores, 9 numbers by Pavitra Boru, whom we have offered, and Bhabadev Mohanta only 1 number.
Right.
Ongoing work 12 numbers in favor of Pavitra. Bhabadev also equal 12 numbers.
Same.
Out of which 80% progress,
326.
5 numbers in favor of
So
Pavitra
that's
Boru.
an evaluation they have done.
We have done
This
it, Lordship.
Statistics available to them. Yes. And that-
Far ahead, Lordship, if you compare between these two.
This is basically what you call subjective satisfaction.
Exactly, Lordship. With objective parameters.
This is very substantial. Works completed 24 as compared to 13. Works above 5 crores, 9 as opposed to 1.
Huge difference, Lordship. The capacity is far better.
Yes.
So this is our case, Lordship.
So you are supporting the appellant as.
Yes,
so far as-
Lordship. Our decision-making process, Lordship.
Yes,
Basically,
of course, of course.
we do not have any blue-eyed person. Both are our
There
contractors,
is no such allegation even.
Lordship.
There's no such allegation.
So whether our decision-making process was proper or not, that
All right.
from that point of view, I'm making my submission, Lordship. This is my humble submission.
Contract was awarded, which has been reversed on the ground that he was not having the sole ground. Last 5 financial years. That is the sole ground. What will be? We'll close it for. Anything else to say? You are.
Yes, Your Lordship.
Yes, please.
My lord, Justice Seke had an occasion to be a part of bench which had heard the matter on the last occasion. The records
Those are things of past.
No, my lord.
Even
there
if
is a
many
relevance.
opinions had been expressed.
That's what I'm trying to express before Your Lordship. The record wherein that processing was made is before Your Lordship.
Yes.
It was pursued. My lord will just pursue that. Now, the stand of the government is that they had made a comparative statement.
Yes.
My lord will only come to page 326 for a minute. My lord.
Yes, we are having that page.
My lord will just down below see the date, my lord.
Yes.
This date is 27/7/2022.
Yes.
Whereas the work order was issued on 26/2/2021. These exercises were never a part of that decision-making process, my lord. It was when the honorable court, during the proceedings of the writ petition, required them to show how they have done it. They have gone and done all these exercises, my lord.
The detailed chart is at page 327.
Lordship, this also, my lord, would see the date. This was also, my lord, procured.
The works performed, they are of prior to the date of NIT.
My lord would see these were done, procured after the orders were passed, my lord, not at the time of the order. My lord will have the records, my lord. The records will speak for itself, my lord. We have seen the records.
Can we ignore these records, sir? Can we ignore these statistics?
My lord, because why this statistics is to be ignored is on the count that these were not the part of the decision-making process. Because these datas were not before the authority when the decision was being taken, my lord. This was during the proceeding of the writ petition they are collated, my lord. My lord will see the records. If it is there in the records, my lord, I have nothing to say. It's not there in the records.
Sakya, what do you have to say on this? Whether these statistics you are referring to in the affidavit, they were a part of your decision making.
Because it was referred to the government said give it to the person who has better record with the department. This is in our first.
But that is a specific assertion.
Yes.
That this was not a part of the record.
Government,
Satisfy us on that.
These are our records.
Please satisfy the court,
Lordship,
that these were under consideration of the authority when the final decision to award the tender was taken.
When it was referred by the chief engineer to the government was on a platter, it was given that both are having 10% below the quoted rate.
Right.
So government said because of the performance of this one is better.
That is
so
what the only query is, whether this chart you are showing to us, which is dated, which bears the date 27th July 2000.
That is what there's a interim direction of the honorable court
for
producing this record.
It's okay.
For
whether
producing
this precisely was the record with the government when the decision was taken for two bidders who had quoted the same price.
All the records are with government, Lordship. The government is the employer.
Show us, please, simple as that. That these very records were available.
Lordship, I have not gone through the records personally because it is sealed back.
We now authorize you to have a look at the record and tell us that these statistics were available when the final decision was taken.
Ultimately, by applying common sense, Lordship, I give all the works to all my contractors. Those records are with me.
We presume because the works were done in the earlier years.
Yes, Lord.
So these records must be available.
With us.
Just make a statement. That is what
in our first affidavit, before this additional affidavit also, we have mentioned it. It is not this is a subsequent.
Justice must not only be done.
It has to be seen.
Appear to have been done. So you just satisfy the court that these records were there. We'll take it up after a while. To just have a look at the record.
Lordship.
And just flag the documents.
Lordship, I'll do that.
We'll have a look at the documents and then things will be clear.
Lordship.
Pass over.
Letter number 9.
Yes.
But here the appellants who are respondent private response matter 789 in the petition filed by the private response here who challenged our appointments on the ground, my lord. We passed out diploma from registered institutes, not government recognized. And that is what the qualification, my lord, the terms was in the advertisement. We applied. The advertisement was of 19 to 2011. Then, my lord, we were called for interview. We were selected and appointed in 2013. The writ petitioners who came before this court filed the writ petition in 2018, being WBC number 6279 of 2018, after 5 years of appointment. Then, my lord, against that, my lord, the writ petitioners got the writ. Their writ was allowed, and the learned single judge directed the government to recast the select list. Against that, again, we approach this court, my lord, then there is, we are given liberty to file a review, review was rejected. That is, my lord, page 165. Then now we are before lordships.
The basic allegation is that you are not having the requisite qualification
From
on
the
the date you are
recognized-
selected,
Yeah, yes, that is.
recognized institution.
Now, my lord, my contention is, your lordship will kindly see
Yes.
in paragraph, page 93 of the counter by the, counter by the government, official respondent number 6.
Page 93.
Yes, 93, my lord.
Yes.
They have not, they did not support the case of the writ prisoners. They rather supported us. Because when we applied, the government verified our documents. They knew that we are from
Verification
the
is okay. What do the terms of
advisement clear that it should be recognized.
recognized? So you are not qualified.
Yes, but my.
Please read the judgment of Alka Saxena.
Yes. My lord, my contention.
Those were motor transport inspectors working for 5 years. They were sent home because
Yes.
they were not having the requisite
Yes,
qualifications.
I worked for 10 years. And my lord,
Immaterial, sir.
my lord. And my lord, my contract grounds here in the edit table is that delay and lapses for 5 years. They work after 5 years.
That would not validate your qualification. Even if
That
it
is
is
true.
delayed.
But one more contention I am that your lordship kindly my lord, accept my submission that government had condoned and waived that recognition part. Otherwise, they would have called for interview and they would have interviewed.
the selection
They would
process.
not have appointed us.
Did they have the power to condone? If the
No,
condonation
because there
was
was
to be
no
done,
rule on
if the
that day.
condonation was to be done,
Yes.
then it had to be done across the board.
Yes,
Other candidates having similar qualifications as you,
yes.
they would have been at liberty to
No, they were
apply.
not selected. They failed in the examination. They failed in the selection test.
There may be many who might not even have applied, knowing that they did not have the requisite qualification. So
So, my lord,
how do we discriminate?
no,
with
anyway,
those?
yeah, it is a lordship's discuss the matter. My submission is that government waived their condition, number one. Number two, there was a
Where do
delay in
we-
lapses
where
5
do
years.
we find the waiver from? Where is the order whereby the government relaxed or waived
No,
that condition?
there is no order, but by
you
accepting
want
our
to deem-
application and calling for interview and appointing us by their action.
That is what we are saying, sir, that merely because you have been offered appointment against the requisite norms, whether that would validate the action.
Yes.
Show us one judgment which says that even if a candidate is not qualified, he is permitted to hold on to the
No,
post.
qualifications there. Otherwise, they work for 10 years, but without any blemish or without any complaint, that is there. They could operate matter as a laboratory technician, there is no doubt. But only the tag is matter, the barricade is the recognition they recognized. Recognized and they registered. There is the difference, my lord. Now, my
What does the
humble submission, my lord,
What do the rules say, sir?
rule was not there on the jet advertisement. Rule came thereafter in
All right,
2012.
then what does the advertisement say?
Advertisement, that is clear,
Recognized.
that is clear.
So you just show us one judgment that even if it is the recognized qualification is there, still a candidate who is not having that recognition, recognized degree, the candidate can still be appointed.
Then,
And a wrongful appointment gives
No, my lord, my lord, my submission, is-
right.
my lord, whether our appointment is illegal or irregular.
It is illegal on the face of it, sir. You are not having the requisite qualifying degree. What to do?
That is true, my lord.
That is true, then well, your appeal has to fail.
I leave it here.
Yes,
Actually, my lord, they have been terminated and termination is under challenge in WPC 7106
By
of
other
20.
candidates.
Pursuant to the learned single judge's order,
Probably that writ will also meet its fate accompli with this judgment.
Nobody knows, my lord, how the air blows in the Supreme Court, my lord, that will determine.
Supreme Court, that, do you have that judgment of
Motor General,
Yes, sir.
Motor General.
Yes.
Delay,
motor transport inspectors? Mostly it is Alka Saxena or
my lord, on point of delay latches?
no
On the
qualification.
data.
They had
Oh,
worked-
yes.
the inspectors that worked for 5 years,
Yes, yes.
despite not having the qualification.
Yes.
The Supreme Court refused to interfere and give them the relief. Can we have that judgment, please?
That presently I don't
This
have. my-
judgment by Honorable Justice J. Singhvi.
Okay,
Yes.
we'll get it, man.
Any other judgment? You are having.
No, no, my lord, I'm not bringing any judgment. I have not brought any judgment for the simple reason, my lord. He themselves fairly admitted that they do not have the qualification.
They have been. They
No,
have
we have got the
admitted-
qualification, not that
They
I but only
my lord.
recognition in
My
my lord
there's
register
no
part.
question of invoking equity in this situation.
That's true. That's true.
On the delay point, my lord, I would have relied upon that motor general case merely because there is delay and illegal action does not become legitimate by the
And whether the
operation
failed
of the-
candidate mal who could not get selected, they could challenge. That mal 95 Supreme Court
This
is
is
there.
in public interest, sir. Persons not qualified holding on to the post. That is not in
Anyway.
public interest. Dismissed.
Item number 10.
I'll get it. Motor vehicles is. This is GSC. It is that important record of the mother. Do we have the record?
Yes, government advocate is bringing my lord.
Yes. What does her mother's record say?
My lord, it's again now a different story. From the very inception, 2004, when she, as an muscle worker, she entered into the service, she was general. Then in 2007, when she became a LDA with promotion, she was general. Then this morning again, I have received some other documents. In 2016, when her name was forwarded for promotion, my lord, 16 and 18, twice. The seniority list, her thing is in general. These are the documents, my lord, I have to place before lordship. If now altogether something else. I'm just placing this before your lordship.
So now this story has taken a different turn.
No, my lord.
No.
No, it is in the same trajectory. I'll place it. Let my lord. Lanefred is trying to anyway, my lord.
No, he is not trying to say anything. He is just putting the record across as desired by us.
Exactly.
Purnima Datta.
Purnima Datta, my lord. Yellow. Yellow pistol.
Would Mr. Chaudhary like to have a look at the records?
Yes, certainly.
Please have a look at the records and come back, please. All along, she is a general candidate.
My lord, my learned friends today fairly stated the facts. My lord, post community became OBC only in 1993.
So these are records.
So therefore, my lord, when she entered service, there was no occasion that she would be described as an OBC.
Why?
Because, my lord, this community
93.
was pursuant to Mondal Commission report, my lord. Only in 1993 the post community. Therefore, when she entered service in 1988, there was no occasion, my lord.
But there are corresponding records of the subsequent years also.
Yeah, no, my lord, there are. I have also brought it. That my learned friend will not place.
No, you have the liberty to
Yes.
do so.
My lord, only in 1993 that this particular community was,
so
brought under the scope of OBC, my lord.
Okay, okay.
Now, my lord will kindly have this, the one which I have given just now. This my learned friend will not produce.
Okay.
This is a communication, my lord, sent in 2005. Kindly come to the next page, my lord. With reference to the above, I have the honor to submit herewith the list of master role workers as per performance supplied from Chief Engineer Irrigation Department.
Purnima Bora.
Purnima Datta, my lord.
Datta.
For your
serial number. Serial number.
Third page, my lord. Serial number 120. Kindly see, my lord, column number 3, date of 4, date of engagement 1188, HSLC pass diploma in so and so course OBC.
This.
My lord, when I entered service, this could not have revealed.
We understand.
My lord, we know this document will not be produced by my learned friend.
No, he need not produce it. It's the court's prerogative to get the records. Now all the inquiries, they are all redundant now. This is a document corresponding to the year 2005, wherein her mother's caste is OBC. What else is to be seen?
But my lord, till 2028, she continued to be a general in the gradation list.
Till 2000?
2018, my lord.
That is fault at your end. In 2005, our service records reads OBC, cock, coach, whatever.
My lord, even the
Can
inquiry
you-
also revealed that I belong to, I
Can you
mean,
dispute this record now?
yes.
The value of this record is unimpeachable.
Yes.
This corresponds to the change in category post 1993.
Yes. And my
So
lord, in
do
any
you
case,
want these documents to be brought on record by way of an affidavit, or we should rely upon it straight away?
Yes, those records should be brought.
Record original is here. You want that we should have a look at, rely on the record as such, or it is to be brought on record through an affidavit? What do you want? Because there is no disputing this record, sir.
Let
You have a look at this, please. दिखाइए सर को दिखाइए record.
Subject to correction, this came in 97, not 93.
This is a record of 2005, sir. Wherein our service records refers OBC, coach. And there's no reason to doubt this. At this stage, with reference to this one only, the certificate of this monsoon Borokoti in the 2006, she procured that OBC certificate.
yes, when I was in class 9. And my lord, page 51, the notification is of 93. Page 51 of the writ petition, central list for OBC for the state of Assam. Coach Rajbangshi, in fact, my lord, this community was by an.
You just place this on record with an affidavit.
Yeah. Okay, my
I think that would be better.
end of the matter, yes.
Yes. State government file an affidavit with the corresponding dates as per which her age, caste was entered. And then, because this is the record of the government, so you have to incorporate this also in your affidavit. We need not go on their affidavit. Do this immediately.
May I have a copy of it?
Yes, of course. We'll provide you.
It's okay, my lord, this is a copy I've given,
This copy you are having,
that he can retain.
the government advocate has shown us the service record of Purnima Datta Barakati, mother of the respondent number 1 writ petitioner. Shri Ken Chaudhary senior advocate has also presented the record of Srimati Purnima Datta for the year 2005, wherein her caste is reflected, recorded as OBC coach.
Within bracket course.
Coach. These facts be brought on record by way of an affidavit, be filed by the United Government Council. List on 13th.
15th of March.
13th March.
Deeply.
Hand them back. They'll file it in form of an affidavit.
Item number 11.
Yes.
Lordship, in this case, my lord, we have still the order of honorable single judge. Lordship will find it page 24, my lord. It starts from page 24. The petition appellant here is working as an, my lord, assistant teacher, a Hindi teacher, my lord, having all requisite qualification for the consideration of case or promotion or in charge for the post of headmaster, my lord. Now, subsequently, my lord, the government has taken a decision to upgrade the high school to higher secondary school, my lord. That upgradation order, my lord, will find as page 56, my lord. The whole thing is based on that, lordship. 56 million.
Yes.
Now, lordship will kindly see the conditions as per government approval conveyed by letter number so and so, the following 112 number of high school. I'm one of that school, one of this school, my lord, are hereby upgraded to higher secondary school on the following criteria and conditions. One, there should not be any amalgamation proposal. There should be minimum 2 additional classroom available. There must be minimum 4 number of graduate teachers having postgraduate degree in minimum 4 core subjects, and there shall not be any new post creation. Meaning thereby, in my humble understanding, my lord, there should be no creation of the post. Because for the higher secondary school, as per rule, there should be a principal. But for the high school, it should be headed by headmaster, my lord. But it's just a mere upgradation, my lord, because of the NEP 2020, my lord. Now, my lord, in the context of that, my lord, my case was considered, and I was, my lord, appointed as, my lord, the in-charge headmaster, my lord. That, my lord, will find at 76, right? Huh? 76 lordship. 76 lordship. Until further order, Majum Lehar Lodge Court Appellant, BA Parangat, Hindi teacher of so-and-so school, Hailakandi, were allowed to hold the charge of the headmistress of the same school, along with the financial power to draw and disburse the salary, etc., of the staff of the school, in addition to her normal duties as Hindi teacher under FR so-and-so, my lord. That is the order. Now, this order, my lord, was cancelled by another order that my lord will find its page 77.
Yes.
Now, if your lordship kindly consequent upon retirement of so-and-so, Hailakandi inspector of school, Hailakandi Bhai. Letter.
Yes. I know. Yes.
My lord, Bhai, letter number so-and-so, submitted a proposal for placing in charge headmaster of Monachara High School. In the subsequent period, considering the seniority and other criteria, the appellant, that is Timothy so-and-so, BA Padangat, Hindi teacher of so-and-so, are temporarily allowed to hold the charge of the headmaster of the same school by this office order number so-and-so. On the other hand, the inspector of school, Hailakandi, again submitted another proposal for placing in charge principal of the high school along with the higher secondary, along with the relevant record by letter number so-and-so. On perusal of the available record, it appears that the Monachara High School has been upgraded to higher secondary school in the year 2021. As such, the head of the institution should be placed considering the qualification and other criteria for the post of principal adhere to the existing rules. So, my lord, this cancellation order, my lord, they proceeded on the ground that there should be a principal. But whereas the upgradation order clearly states there will be no additional post of principal. Now, my humble submission,
Maybe so, but a person not having qualification to hold the post of a principal.
I am not claiming for the principal, my lord. I've been put as an in-charge headmaster, my lord.
We have already decided the issue wherein the inspector was given the charge.
Yes,
because there was no qualified teacher to hold the post of headmaster. So this. I am qualified for headmaster.
I am qualified for headmaster, my lord.
We will just pass on the order to you. You already decided similar matter. Comment council.
Yes, sir.
There was one order which we passed.
Yes, sir, Lordship. Your Lordship.
All right, we'll find out on the record. We're just passing it over. Have a look at that order. Identical controversy we have decided. Okay, pass on it. We are passing it over. We'll share with you the order which we have passed deciding similar controversy.
Item number 12 to 33.
Sorry.
Service of life, my resignation will be. Mood case to that petitioner
Item number.
Item number, it is the first item 12. May I please, Lordship, I find an Lordship to struck the name of the petitioner number 2 in the WPC 2729/2019, Your Lordship. Your Lordship,
Deletion of name.
yes, Your Lordship.
He has got the relief or what?
No, no, Lordship, he has resigned from the service, Your Lordship. The resignation is page 18, Your Lordship. He is no longer have any grievance against the
Against, you want to delete the name of which petitioner?
petitioner number 2 in WPC number 2729 of the 2019,
Sirajul.
Sirajul Islam. Yes, Your Lordship.
Government, any objection?
No, we have no objection.
You heard, MS?
S. Nazneen.
S. Nazneen, learned counsel for the petitioner, applicant. This application has been filed by the applicant seeking deletion of his name from the array of petitioners in WPC number 2729 of 2019, where the petitioner was at serial number 2. The learned counsel for the applicant submits that the applicant is no longer in service, and by letter dated 1/6/2020 has already resigned, and consequently resigned from his service as a craft teacher in a non-sanctioned post at so-and-so school. According to the learned counsel for the petitioner, since the petitioner has already resigned, he does not wish to pursue the writ petition so-and-so as one of the petitioners. Government counsels representing the respondents have no objection to the prayers made. Accordingly, the IA is allowed. Name of the applicant, Sirajul Islam, is directed to be struck off from the array of petitioners in WPC number 2729. Registry is directed to make necessary endorsements in the court's title and place it before the court within a week. Copy of this order also be retained in the case records of WPC 2729, 2022. Sorry, 2019.
What about the other matters?
I allowed.
Lordship, a lot of other cases are not, which were batched together, are not
They are not
listed today.
because this today it comes up only on the
Only for a
IA.
limited purpose, Lordship.
The remaining bunch of petitions to be listed along with the connected matters on. Can we fix them on a particular date?
Some of the senior counsels for the appellants are present.
I am
here.
also there because there are few cases which are not being listed.
My lord can have it on a date convenient.
Earlier, there was an exercise of
Yes,
verification
segregating.
No, no, seg-
No, they're not segregating.
Categorization was there.
Categorization.
Categorization was already done by the registry.
Find out
No,
if
no,
there's date fixed.
there was a verification done by the department in respect of documents submitted,
Yes.
etc. So is that exercise complete by as on date?
One affidavit has been filed. The concerned assisting counsel is not here today.
All right, so we'll have it.
Before that date, if it is not filed, we'll file it before that date.
We'll have it in somewhere in the last week of April,
Yes, Lordship.
26th April, maybe
Lordship.
26,
27th April.
27th, Lordship.
27th April.
Lordship.
List is matters along with WPC so and so on 27th April. Please take note down the names of the learned councils for both parties.
All these cases, no?
Exactly. It's a-
Pass it on to the learned council.
Mr. Ghosh, I think. Have a look at this order, Mr. Ghosh.
Yes. Call him, yes.
Item number 1 to 5.
Got a copy of this?
Yes, I have received a copy.
This is something strange and prima facie unacceptable. If it is to be used as a detention center, why the term prison is to be?
Lordship, I have to get up-to-date information, but prima facie, what I have come to know, that the capacity of this Matia campus, it consists of 3,000 persons.
Right.
Here hardly less than 200 persons are there who are in
Sir,
detention.
Maybe.
If
If
we
you
part,
want to enhance your prison's capacity, do it in this place where the prisons are constructed. Why do you need to convert this detention center to a prison?
that can be done, and we can also partition it also completely with a boundary. That can be.
Why?
Because
This situation regarding the juvenile justice homes, same situation is prevailing. They are housing the CICLs and CNCPs in the same campus. They just say that we have partitioned, which is contrary to the spirit of the act. Can't do it. You have to have a separate place.
Definitely, Lordship. In fact,
So
some of the
capacity building
overcrowded
exercise-
prisoners were shifted there.
Capacity building exercise you have to do for the prisons. You can't encroach upon an institution which is meant only for persons who are actually not convicts. They are not offenders.
Lordship.
They may be in a wrong place at the wrong time. Maybe because of number of circumstances, but you can't keep them with ordinary criminals.
In any case, Lordship, let me obtain instructions and we'll definitely correct ourselves if there is any wrong.
You need to do that.
My lords, I have a humble submission, my lords.
Yes.
With the kind leave of this honorable court. My lords, there are two scenarios today. Before this notification had come into effect, the impression that was given before this honorable court was that once Matia is set up, it is going to redress all our grievances. Then the only question which would have remained is a question of the antecedent illegalities which were committed because of the three notifications of 1st of December 2009, 5th of April 2010, and 24th of September 2015. By these notifications, Milords, the state government had set up the district jails as temporary detention centers, and this is what we had impugned.
Right.
As of today, Milords, there is a sustained continuing illegality because of this notification which we have brought on record by this affidavit, Milords. I have a humble prayer, Milords, that in case the state decides to sustain this notification, Milords, I may be allowed to impugn this.
You can't anticipate.
I can't anticipate. Milords.
Let them come out with a solution.
Very well.
We hope that with the intervention of learned
Very well.
Advocate General, we'll get a proper solution. And what we have indicated is likely to be conveyed to the state.
Very well.
Then let this be a dedicated facility for
Yes.
these these kind of persons.
Yes.
And not mix them with the prisoners.
Yes, yes, absolutely.
We hope that the Advocate General has that prowess in his office
Yes.
to ensure that this illegality is not committed.
Absolutely.
We will get it done, Lord. No difficulty.
Absolutely.
Advocate General Shri Saikia praised for short opportunity to take instructions regarding government's made in additional affidavit filed on behalf of petitioners in writ petition number 6/2020.
Let it come on Friday, Lordship, by Friday. I'll
List on Friday.
How many inmates have been transferred? Any?
Less than 200. We have given the figures in our.
Less than 200. From all parts of the state.
Far thinking process which has been started.
In fact, there were more.
Build a center of this magnitude. You must be thinking of bringing in people from other areas also.
Lordship.
So if you start bringing ordinary criminals into the facility, you'll be compromising on this.
Absolutely, Lordship. That was the precise why they should not be mixed up with the jail people. It has become reversed now. So we'll definitely look into this.
Yes.
The only thing is a lot of
Prison
detainees were
reforms-
already released. That is
Prison
why this.
reforms are required to be done. The Supreme Court judgments are there.
Lordship.
So you have to do the reforms in the prisons.
Lordship.
You can't start propping up and building prisons all over the state.
Now the thing is that earlier the detainees were given the position in the prisons. Now it is reversing. So we'll get it corrected.
Milords, I have a humble prayer, Milords. On 3rd, Milords, I'll be indisposed, Milords, physically. If it's learned AG is,
14.
if 9th or 10th is convenient for the learned
Let it
AG.
come day after tomorrow, Lordship. We'll get it.
Yes,
Second.
Thursday, yes.
AG Sahab, have you gone through that item number 8?
Yes, I have gone through it, Lordship.
Okay.
The government had a peculiar problem. 3 persons having the same rates was sent to them. And they said that he should be given without analyzing anything. There are 3 persons equally placed.
So can you?
Suppose we have given it to him. The thing question would have come.
Okay.
So now we have, due to the interference of the Honorable Court, because this exercise was done in terms during the hearing. It was finally
Would
said.
it be prudent for you to have this exercise again after examining all the records of all the candidates
Yes,
who are having the same financial bid?
same financial bill.
You can reconsider at your own level.
Definitely, Lordship.
Take an objective decision.
Yes, Lordship.
A reasoned order.
But whatever we have said, it was placed on record.
Yes.
They have not controverted also.
So would you be able to make a statement that you will consider the bids of all three
All 3,
qualifying bidders
Lordship.
and come out with a proper
With
solution?
a objective parameters on the basis of objective, will finalize the persons who is qualified. I'll do that, Lordship.
Is it acceptable?
Milord.
Keep it pending, of course. Let us have the decision.
Right.
The original records have been presented for the court's perusal. It is not in dispute that 3 bidders offered the same financial bid for the work in question. However, only the appellant was qualified. His bid has been interfered by the learned single bench by virtue of the impugned order. At this stage, the Advocate General made a fair offer, fair suggestion that the government may be advised to re-examine the entire matter, keeping in view the financial documents, financial and other documents of all equally placed bidders, and to take an objective decision regarding the person to be qualified, to the bid to be qualified for the work in question.
Including the past works. That's also.
All associated documents.
All is highly obliged.
The exercise in this regard be completed. The councils representing the respective bidders are agreeable to this suggestion. No. Very well, we give a direction. We feel.
Not agreeable because, my lord, the government all along, in spite, my lord has seen from the record, there was no material at all.
Sir, the material is of the corresponding dates. Even if it was not there, ultimate discretion of the employer.
Back to the issue. Even if it was that, my lord, I would not have had objection. It was just a picking up of.
Why do you apprehend that your bid might not be accepted?
My lord,
There is no malafide alleged
my lord,
against anyone.
If I open up the facts, my lord, if the documents are produced, my lord will realize. There was even a FIR filed against me, my lord, on a false notion. That I had brought a letter of the chief minister for awarding the work to me. Thereafter, this honorable court intervened and I was saved.
These are internal bickerings amongst the contractors. Government has nothing to do.
My lord has said that. My lord,
For all we know, you may all form a consortium and do the work together. Yes.
My lord, can one line be observed?
Yes.
Because my lord 43F, that condition is a pre-qualification.
Let them come out with a reasoned order. Then we'll permit you to argue on that. Even without.
My lord, they'll not award the work. My lord, they'll only.
Yes, they will take a decision and bring it to the court's notice, whether to accept it or not. That is for the court to see.
If that liberty is there, not happening.
Yes.
Would it come on 13th, Lordship?
The decision so taken after due consideration shall be placed on record for the court's consideration on the next date. Re-notify on 13th March.
Lordship.
Highly obliged.
Okay. Financial. Contractual matter, hardly there is any scope for it. What is it? No, that. Item number 7. 11, was you that teacher matter? Yes.
Item number 11, time being. Lordship, I've gone through this judgment, Lordship, subject to, and my humble understanding, subject to your Lordship's correction. That is regarding, my lord, the person was not eligible for the post of headmaster in that context only.
Yes.
Here, my lord, are eligible for the post of headmaster of the school before upgradation. And
So now post upgradation, whether the eligibility is there or not.
my lord, post, there is no upgradation of post as such.
No, after upgradation of the school,
Yes, my,
whether your client
yes.
is eligible to hold that post or not.
I am eligible to hold the post of headmaster also, my lord. Again, after upgradation, that is my humble. because
Let me rephrase the question.
My lord,
Supposing the post that you're holding today
my lord,
falls vacant
yes, my lord,
in the upgraded school,
yes, my lord.
what are the criteria necessary to fill it up?
My lord, if it is a post of headmaster, my lord, it is under.
No, it's not a post of headmaster anymore.
But principal post has not been created. That is the problem, my lord. Because upgradation order clearly postulates
So
that
are you saying that you're holding the post of a headmaster in a higher secondary school?
in the high school, because there is a concept of headmaster in the higher secondary school, my lord. Only it is a mere upgradation. If your lordship look into page 56, my lord, once again.
You are upgraded to higher secondary schools.
School only, my lord.
Then
There is no post of principal. Nothing. If your lordship kindly look into page 56.
You should be allowed to work as a
so
headmaster.
there's no post because you'll automatically be upgraded to the post of a principal.
No, it's a conditional upgradation, my lord. If your lordship kindly look into page 56 again.
Who's for the government?
If they say
Mr.
that
Bora,
it is
Mr.
a
Das.
principal, that's a different. If you say department is different.
Well, please,
I'll inform them.
okay. We should notice,
Lordship.
let the government get instructions in
My lord,
respect of the notification or order dated 14th September 2021, Annexure 5,
Lordship.
page 56. Is there any respondent, private respondent?
No, my lord.
The counsel for the appellant will take steps on the government department, government councils and serve extra copies.
Lordship.
Matter be listed after 2 weeks.
Lordship. Obliged. My lord. The import order may kindly be stayed in the meantime, my lord. This order which cancelling my
Status quo as on date
my-
till the next returnable date.
obligations.
Rudderless. No one to administer things. Was
Item number 34 for order.
Yes. Family court.
May I please, Lordship, in this case, Lordship, the local council also could not may contact the petitioner, appellant also, Lord.
The same prayer was made on the
Yes, Lordship.
previous date also.
Lordship, he tried to contact today morning. I called to him. With the matter from Silchar. Lordship, he sent his junior, but the man was not found in that address also. Lord. This one was directed to make payment of 2 lakh to the respondent. If this is the
Third time. 4 weeks.
SCKL appears for the appellant. 4 weeks further time is granted to take steps.
Lordship, we were directed to take the
Compliance.
Permitting him to make a statement regarding the compliance order. List accordingly.
Item number 35 and 36.
Lordship, two writ appeal is combined here, Lordship. One was preferred, one by the private respondent, and one is informed by the APSC, Lordship. Lordship, what happened, Lordship? In year 2013, Assam Public Service Commission had advertised the combined competitive exemption 2013, Lordship. The respondent, Lordship, here. One Mosumi Madhav, Lordship, was the writ petitioner in the original writ petition number 4848 Lordship 15. Also applied in this case, and she preferred the option number 9 Lordship.
Appellant has a higher, had scored higher than the
Higher
respondent.
than the respondent, Lordship.
But the option was,
She preferred.
second preference was given to some other post.
Lordship. Moreover, Lordship, another important thing is that there are 2 posts of active female category, Lordship. In the respondent, Lordship.
In which posts? APSC?
APS. Combined competitive exam 2000.
No, for which category? Police.
APS, Lordship. The writ petitioner respondent, he preferred 9th of preference. And the respondent number 4, Lordship, who is the appellant in another case, the appeal, Lordship, he preferred the second option. That's why, Lordship, though respondent number 4 was scored much below than the writ petitioner, he was given the APS service, Lordship. And this was the, Lordship, crack of the matter, Lordship.
What does your rule say?
Rule says, Lordship, that service
appointment to the post, the APSC recommend on the basis of the preference, Lordship. Lordship.
Rule 2.
Lordship, the parent rule is that Assam Public Service Commission
Single judge says that the
Assam Public Service
selection
Combined
can be
Competitive
appointed
Examination Rule
at
1989 rule.
irrespective of the preference. Sir, if that is done, counseling and deputy. If the you have to go with
Page number 114.
it.
Lordship, page number 114, Lordship. Start that Assam Public Service Combined Competitive Examination Rule 1989, Lordship.
143.
140, Lordship. That in this book, Lordship, Assam Service Manual.
89 rule.
Lordship. Lordship, I am referring the rule number 3, Lordship, first. Combined Competitive Examination. Page number 144. Lordship, got it?
Schedule 2.
Schedule 2, Lordship. The schedule 2, rule 2, Lordship. May I read, Lordship? The examination will be conducted by Assam Public Service Commission in the manner and with the syllabi prescribed in Appendix 1, Appendix 2 of the rule. The date on which the place so and so, that rule 2, Lordship, 2A, the candidate shall be required to indicate in the application. Lordship, got it? In application form for the main examination, his stock her order of preference for various services of the post for which she would like to be considered for appointment in case she is recommended for appointment by Assam Public Service Commission. So in the application, Lordship, if I draw your attention to the application form, Lordship, application form is annexed in the memo of application, Lordship. Page 53, Lordship. The 11 is page 55, Lordship. Hmm?
What is the reason for arranging the candidates in the order of what is the weightage of the percentage or the weightage of the marks position and
In another provision is also the same rule, Lordship, clause
whether these
14.
rules have been interpreted by this court at any earlier point of time.
In the Supreme Court, Lordship, there is a judgment, Lordship.
Let us see.
Lordship. Lordship, I have supplied in earlier occasion on that.
What is the name of the judgment?
Name of the Union of India versus MVVS Murthy, Lordship. Dada. In paragraph 5, Lordship, I am directly referring to.
This segment of the look at this secretary AP SC versus by VVRC and what. I think that is closer.
Dada.
This is a closer issue.
No, rule kita paham. Ekonomi rule kita. Itu ini kita akan terlalu. Artinya kita akan terlalu.
MBBS Mukti was a case wherein the candidate was not found having the requisite number of marks in merit to be selected as per his preference. He was not entitled to be recruited to the IAS, the service of his choice. Closer to the MBBS Murthy is a slightly different situation. Because therein, the person who he was not found qualified for the post position he opted for on the basis of marks. Herein, that is not the situation. So this judgment probably does not help you, gentlemen. There is one more judgment which is cited before us. This is Secretary APSC versus YVVR Srinivasalu.
That's the judgment cited.
That was cited by the Honorable Single Judge in respect of preference. When two candidates are in the same rank, then only preference should come. It was the observation given by the learned Single Judge. But in our case, Lordship, here the preferences is not which was interpreted by learned Single Judge. The preference of service and post, which is embodied in the 89 rule as well as 2010 APSC conduct and procedure rule. The candidate were allotted cadre in respect of the preference which he or she chose, Lordship. In this case, Lordship, the respondent, Lordship here, that Dr. Manubhi Machap, he opted APS 9 preference in his application, page 55 in a memo of appeal. And the appellant, in another case, Dr. Dipti Mali, he opted second preference, Lordship. So APSC, while allotting cadre, Lordship, choose the first choose the cadre which the candidate has preferred, Lordship. So the APSC always first try to fill up the SCS cadre, Lordship. After exhaustion of SCS cadre, then they go road to APS cadre. As the Dipti Mali, the appellant in another case, opted second preference, so he was allotted APS cadre first. And for the respondent, Lordship, who opted 9 preference, by that time she was considered that APS post has exhausted, Lordship. That's why she could not be selected. This was the first one. And second thing, Lordship, apart
Was
from
she selected in another?
no, Lordship,
She has not been
not been selected, Lordship, because all the cadre has been filled up by the time that 9th preference was taken up.
Not being selected only because of preference given.
Preference, Lordship.
Meritorious candidate gets shunted out only because the preference filled.
Unfortunately, not in that service and the IAS, that's the formula for followed, my lord. And the 87 judgment, there are 5, my lord. If my lord,
There are 5.
Murthy, my lord.
We are already having it. We are having it. Yes.
My lord, para 5. Can I just take my lord?
Yes.
Indisputably, the respondent confined his preference only to IAS. The note appearing below column 22 in the application form reads thus. In respect of services posts not covered by the entries above, it will be assumed that you have an equal preference for those posts. You will not be therefore considered for any of those services if you cannot be allotted to the services of your performance. You will therefore be considered for any of those services if you cannot be allotted to the services of your preference. The real meaning of this note appears to us to be that if preferences given by the candidate are not available to be accommodated on the basis of results of the candidate's preference in the selection examination, instead of being rejected, he would be available to be considered for the other service. As already pointed out, the civil services examination is a combined examination of several services, and when a vacancy is not available within the field of the candidate's choice, it is open to the central government to consider the candidate for other services. Now, my lord, the effect of this note is not that preferences given by a candidate securing a place lower to the respondent would not be entitled to his preference because he has been placed below the respondent in ranking. If ranking alone is to be the test, preferences would have no meaning. On the other hand, the procedure that the preferences are acceptable with reference to the position in the final list till vacancies in the service are exhausted is the most logical one and meets the requirement of the scheme. Merely because the respondent was placed at 280th in the merit list and someone else at serial number 291 was being offered the Indian Police Service in keeping with his preference would not give the respondent any cause of action. In course of hearing of this matter, we called upon then my lord, it said that he'll be accommodated in some other service. That 141, the Supreme Court did it. But my lord, the thrust here is in the civil services, there are, I'll show that, amalgamation of posts. I may not be, my lord, by my inclination, I may not like APS. I may like superintendent of taxes. So, my lord, the option is given to me. I give superintendent of taxes number 1. Now, when the posts of superintendent of taxes are taken up for being filled up, it will see the options 1. Then it will go for the marks. The highest person obtaining the marks and serial number 1, option number 1, he will be first accommodated. This exercise will go on for
dual merit list prepared.
dual.
Virtually first on the basis of preferences seen on merit, the candidates appointed. Then you go on to the next one.
If, my lord, it's not filled up.
It's not filled up.
Then, my lord, they'll go for the second preference. Person who has given second preference. But the only issue here is, say a person has given preference number 1 and say, my lord, he has got 1000 marks. Another one has been given preference number 1 and he gets 800. The 800 number mark cannot be appointed before the 1000 man is appointed. Yes. That's the only criteria.
Merit is to be ignored as against the preference.
Preference. That much only. And herein, my lord, there were, in addition to the, my lord, the respondent writ petitioner, there were 2 other ladies who had more marks than her in the selection process, my lord. Okay. If I may just take my lord quickly through the my lord can have appeal number 79, my lord.
How is the learned single judge dealt with this?
My lord, honorable single judge erred in one direction, my lord. He took the preference to be the normal preference, which says everything being equal, preference would come in. And by applying the 2003 judgment, proceeded in the matter. Therein, my lord, I humbly submit the honorable single judge erred, my lord. That, my lord, would find at page 81, my lord.
Yes.
79, para 15, my lord. In case of secretary so-and-so, reported in so-and-so, the apex court in para 10 held as follows. Both on account of the scheme of selection and the various stages disclosed as necessary to be undergone by every candidate, matter of actual selection for appointment in question, the candidates were required to be selected finally for appointment on the basis of the rank obtained by them in terms of the inter-se ranking based on merit of their respective performance. There is no escape from anyone from this ordeal and claim for any en bloc favorite treatment merely because any one of them happened to possess an additional qualification than the relevant basis general qualification essential for even applying for the post. The word preference, in our view, is capable of different shades of meaning, taking color from the context, purpose, and object of its use under the scheme of the things envisaged. Hence, it is to be construed not in an isolated or detached manner, ascribing a meaning of universal import for all the contingencies capable of an invariable application. The procedure for selection in the case involved a qualifying test, a written examination, a oral test of interview, and a final list has to be on the basis of marks obtained therein. The suitability and all-round merit, if had to be adjusted in the manner only, what justification could be there for overriding all those merely because a particular candidate is in possession of an additional qualification on the basis of which a preference has also been envisaged. The rules do not provide for separate classification of those candidates or apply different norms of selection for them. The preference envisaged in the rules, in our view, under the scheme of the things and also contextually, also cannot mean an absolute en bloc preference akin to reservation or separate and distinct method of selection for them alone. A mere rule of preference meant to give weightage to an additional qualification cannot be enforced as a rule of reservation or a rule of complete precedence. Such a construction would not only undermine the scheme of selection envisaged through this Public Service Commission on the basis of merit performance, but also would work great hardship and injustice to those who possess the required minimum educational qualification with which they are entitled to compete with those possessing additional qualification too, and demonstrate their superiority merit-wise and their suitability for the post. It is not to be viewed as a preferential right conferred even for taking up their claims for consideration. On the other hand, preference envisaged has to be given only when the claims of all candidates who are eligible are taken for consideration, when anyone or more of them are found equally positioned by using the additional qualification as the tilting factor in their favor vis-a-vis others in the matter of actual selection. So, my lord, here the preference was on the basis of an additional qualification. Nothing to do with the present situation. Then, my lord, after discussing everything, my lord, the Honorable Single Judge at para 18, page 83. It even considers the APS service rules. 18, my lord. In the present case, Rule 6.5 of the APS service clearly requires that the selection should be made only on the basis of merit. Thus, just because the petitioner has placed the Assam Police Service as a 9th option in order of preference, the same does not mean that a less meritorious candidate can supersede the petitioner. To supersede the petitioner, Public Service Commission would have to show that the petitioner had been selected for any other service in which she has given a higher option than 9th option. However, the petitioner has not been selected for any other service, that is with regard to her options number 1 to 8. Thus, the petitioner would have to be considered for a 9th option along with other eligible candidates, and selection would have to be made strictly on merit as required by this Rule 6.5 of the Assam Police Service Rules 1966. The story of the petitioner had been different if the petitioner had not made any option for the Assam Police Service. In view of the reasons cited above, the court is of the view that merit cannot be sacrificed on the basis of low or high option exercised in order of preference for a particular state service. Preference cannot be the basis of selection of a candidate at the expense of merit. Accordingly, the selection of the respondent number 5 being bad in law is set aside. Then, my lord, in the 21, in the event of an appointment order is already issued to respondent number 5, the said appointment order shall be deemed to be cancelled as on today, and in place of the respondent number 5, the petitioner shall be given appointment to the said post. My lord, unfortunately, the 87 judgment was not, Murthy's judgment was not placed before the Honorable Single Judgment. If that was placed, maybe, my lord, this conclusion may not have been reached. And the candidates, my lord, from the word go, right from
Rule 3 perhaps overrides the police service rule.
Yes.
Lordship. Rule 3. Rule 3, combined examination service rule. That will override. The merit list that is contemplated in Rule 6.5, my lord, is the list finally prepared by the APSC. It cannot, the rules cannot be, my lord, put above before the APSC selection.
Yes. The initial selection has to be
By the APSC.
by way of the combined list to be prepared by the APSC.
Lordship.
Only thereafter the Assam Police Service
Rules will come in.
Come in picture. Yes.
The Assam Service Rule says 6.5, it's for the inter-se seniority while you get appointed, my lord. My humble submission, my lord, I'm working from, my lord, 21/8/2015. I have been confirmed I'm working, and my lord, I have been confirmed, now I have been promoted also. I have been promoted to additional SP, my lord. Much obliged.
There's an interim order.
There is an interim order protection.
Yes, respondents.
My lord, I will take your lordships to the advertisements which is a page.
We admit and we post the matter for hearing on an early day.
Your lordship, just give me 5 minutes time so that I can clarify the positions. Your lordship, kindly come to page 54.
of the paper book.
My lord. 54, there is the advertisement.
10-5.
It starts from page 49. And the relevant part which I am relying, there is at page 54. हाँ जी, ये तो है आपका 79. My lord, appeal 79, your lordship में can indicate.
79.
79. Filed by Dipti Mali. At page 54. It starts with interview test.
Yes.
My lordship may come to F, column F. The candidates will be allotted cadre strictly on the basis of merit cum preferences opted by the candidates in their application for the main examination. Now, my lord, I will take your lordships to the rule 1989, APSC rule 1989. Lordship may, if your lordship has that rule,
Yes.
lordship may see 14.
40.
14, my lord. Has your lordship got that?
Yes.
Due consideration will be made at the time of making appointment on the result of the examination to the preference expressed by the candidate for various services at the time of his or her application. The appointment to various services will also
Be governed
be governed by the rules, regulation in force as applicable to the respective services at the time of appointment. And the respective services, your lordship will find Assam Police Service. Now, your lordship will
At the
look at
time of appointment. So at the time of initial selection, only the rules of 1989 are relevant.
merit cum preference. Now, your lordship may look at plan of examination, appendix 1. I rely on clause 3.
Appendix 1 to
Appendix 1
yes. Plan of examination.
starts with plan of examination on the
Yes.
top.
Yes.
The lordship may see 3. The main examination will consist from there.
Yes.
The main examination will consist of written examination and interview test. The written examination will consist of 2 compulsory papers on general English and general study, subject and 2 question papers, each on any 2 subjects from the list of optional subjects as set out in the list in section 2. The interview will carry marks as shown in section 2 with no qualifying marks. Then, my lord, down below, this is important, my lord.
Yes.
Marks thus obtained by the candidates in the main examination, written part as well as interview, who determine their final ranking. My lord, this is important, my lord. The final ranking will be from the written test and interview. Candidates will be allotted to the various services, keeping in view their ranks in the examination.
Respective preference. So if the preference is to be ignored and only merit is to be considered.
Yes.
If you are saying that ignore her preference because by virtue of her preference, even though she has secured lesser number of marks, she has been selected, then that would virtually mean ignoring the criterion of preference.
Exactly.
A combined examination preference would hold the sway. You should have to make an assessment of yourself that when I am making the preference, the same thing goes in counseling for the educational institutions.
Yes.
The counseling takes place. The candidates are first given the choice as per the place of preference.
Well,
If they secure the minimum number of marks, they can't say that since I have secured the higher number of marks, please send me to the other institution. That is not done.
Well.
That would create a chaos.
no,
I have to
here,
say they have a case to make out, sir. We'll have to hear the matter finally.
My lord, the appeals were admitted on 10-5-2019.
So we'll confirm the stay and list them for list the appeals for hearing.
For a year.
Lord, can it be, my lord, if your lordship
We'll try and do it as early as possible. That is, stay confirmed.
The appeals are admitted for hearing. The interim order passed by this court YD, order dated.
My lord, 10-5-2019, the appeals were also admitted by that order, my lord. 10-5-2019.
Writ appeal 79, I think it is 27 free.
Lordship, 72 it is.
27-3.
Lordship.
Appeals be listed for hearing as it is admitted by order dated 27/03/2018. Interim order passed shall continue till disposal of the appeal.
Much obliged.
One post required to be kept vacant. It was passed by the read court.
There was no post
If
vacant.
there was a post vacant, your client would have got the appointment.
There was no post vacant.
Since that order was there in the read court, my lord, your
Order
lordship.
has been stayed, sir. 5 years down the line. If there had been a post, there would have been no difficulty at all. The court would have offered your client the appointment then.
Lord, your lordship has fixed it for hearing.
Hearing, we can do it in the first week of May.
My lordship.
Yeah.
Much obliged.
Item number 37.
Mediation. Parties are present?
Your lordship.
We have to close.
Yeah, I had filed an affidavit, lordship.
Lordship, since 12/5/2022, they were seeking time to file affidavit in reply.
They've
Today,
done
they
it
have filed
now.
an additional affidavit with a different cause of action, your lordship. Just
Already-
now I have received the copy a while ago. Totally different cause of action, your lordship.
Let the affidavit be tagged with the file.
That is an additional affidavit.
Okay.
And lordship, one more prayer, lordship. This PIL may be tagged with another PIL pending before this honorable court.
What is the pair in the PIL, please?
This
Is in with regard to an eviction.
Eviction.
Yes, lordship, an eviction is already carried out on 14th and 15th of this
So
month.
now what is left?
Yes, lordship. but,
Lordship, the
ready.
present PIL, your lordship, was filed against the eviction which was carried on the eviction notice dated 28/10/2021. So that eviction was already carried out. All the the affidavit in opposition is also being filed, your lordship. There it is being stated whatever happened, it was followed, eviction was followed, was done following the due course of law, your lordship.
All right, let us have our affidavit on
This
the court.
additional affidavit is a totally different cause of action.
We'll peruse the affidavit and then
Yes,
we'll
lordship.
take a
And
call on that.
This may be, my lord, my humble submission is that this PIL may be tagged with another PIL which is
No,
pending
your
before
lordship,
this.
that is
Let us
totally
first,
different
let us
cause of
first have
action,
your
your
affidavit.
Yes,
Because the
lordship.
eviction process is complete. What is the
Yes, sir.
purpose of tagging it with the other PIL?
In fact,
We'll examine.
in fact, your
Yes,
lordship,
lordship.
today the PIL which is listed, the similar PILs are already being disposed of.
You bring
Only
the
this-
orders on the next date.
Yes, sir.
And counsel for the petitioner submits that she has filed an additional affidavit today. The same be tagged with the file, re-notify after 2 weeks.
Deeply obliged.
I'm obliged.
Item number 39.
39. What
Yes.
is this about?
This is about the PLHIV lordship. And here the petitioner wants to withdraw this PIL lordship.
All right, another लिखा दीजिए.
Heard learned counsels for the parties. Learned counsel for the petitioner submits on instructions that the PIL petitioner does not wish to press this PIL any further. Accordingly, this PIL stands closed, disposed. MS so-and-so appears for the respondents. Any interim orders passed, vacated, are vacated.
Deeply obliged.
Item number 40.
You're getting all your PILs listed today.
It was automatically listed lordship. I didn't press for it, but it was listed lordship.
Yes.
Here lordship, I need some accommodation lordship. Because we had not filed our reply. We have
It's your
short time
PIL.
earlier.
It's your petition.
Yes, lordship.
So Why do you want to file a reply to their
Yes,
affidavit,
Lordship.
counter
Yes,
affidavit?
yes, Lordship, rejoinder.
Rejoinder affidavit.
Yes, Lordship.
How much time do you require? 2 weeks,
4 weeks, Lordship.
4 weeks.
Yes, Lordship.
Learned counsel for the PL petitioner, MS so prays for and is granted 4 weeks time to file rejoinder affidavit to the affidavit filed by the respondent 3 and 4.
And also, Lordship, respondent.
Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. A. Das, appears for respondent 3 and 4.
And also respondent number 6, Lordship.
3, PL petitioner, 6 time to file affidavit in reply in response to respondent 3, 4, and 6.
Yes, Lordship. Deeply, right.
Number 41 and 42.
Please, Lorships. This PL, my lord, we are praying for, my lord, issuance of Aadhaar, my lord. Cards to, my lord, those who are, my lord, involved in the NRC, my lord, verification process, my lord. What happened, my lord? During the, my lord, claims and objection process, my lord, their biometrics were taken for the purpose of, my lord, NRC verification. Now, my lord, these persons, my lord, have not been provided Aadhaar. They've been blocked because of the, my lord, pendency of the NRC in this final stage, my lord. And that's why we are before Lordship, my lord. In fact, what happened in Supreme Court, my lord, another PL was filed, a petition was filed by, my lord, asking for, my lord, Aadhaar, my lord, to be granted to those who have been included in the final list after the draft list was prepared. But our prayer is, my lord, with regard to all, my lord, who have been left out because of their biometrics being taken during the NRC process. Because our cases have got nothing to do with citizenship. And, my lord, Aadhaar is a requirement for everything almost, my lord. All government schemes and, my lord, in fact, even for continuation of bank accounts also. That's the reason, my lord, we had filed this PL, my lord. Therefore, my lord, on the last occasion, this Honorable Court wanted to know, my lord, what is the prayer before the Honorable Supreme Court, my lord. I have got a copy of the, my lord, PL there, my lord. And the prayer there was only for, my lord, those who have been included in the final list.
Can you show us the orders passed in the SLB before the Supreme Court?
My lord, SLP orders, of course, my lord, is in the stage of hearing, my lord. I've got the, my lord, pleadings, my lord, I was asked to produce, my lord. That I'm told, my lord, is, my lord, slated for hearing, my lord, will be coming up, my lord.
So let the SLP be decided.
Yes,
We'll consider the petition thereafter.
My lord.
It is submitted by the learned counsel for the appellant, Mr. M. Dotto, that on similar issues, on connected issues, and a matter is pending before the Supreme Court, which is at this stage of hearing.
That is the trip WPC 1361 of 21.
Being WPC
1361 of
1361 of 2021.
21.
So and so versus so and so. Accordingly, let the matter be listed after 4 weeks. 8 weeks. By which time the learned counsels are permitted to place before the court the status of the appeals pending before the apex court. List after 8 weeks.
Number 43.
My lord, in the writ petition linked with the PIL, the issues are different, my lord. We are the excluded people, excluded from the NRC. And we are mainly seeking a copy of the rejection order by which our claim applications were.
But it is connected.
Lordship will see his prayer number. I'll just.
At page 30, my lord, our prayers in the.
Prayer number 3 at page 31.
There is already an order here at page 38/2022. Page?
Page 31, Lordship. Page 31, prayer number 3.
Same issue.
Same issues.
Just, yes, my lord, the relief at prayer number 3 is same. It relates to Aadhaar, but the main relief is.
This is one of the prayers, unless you want to say you're not pressing it. Prayer number 3, are you pressing the prayer or you're abandoning it?
Yes, we are.
Then let it be listed together.
Along with that.
No, it's already there along. Already connected. 41 and 42.
41.
After 8 weeks.
Item number 43.
This matter is yet to be admitted, but perhaps your lordship would like to admit it and post it for hearing.
Hearing and disposal, lordship. For hearing and disposal, lordship. Lordship, if you may kindly have a fixed date because I'm an outside counsel from my zone.
We'll definitely accommodate you accordingly.
Let the appeal be admitted. Mr. So-and-so Silo, Mr. Silo
Lordship.
appears for the appellant and Mr. I. Chaudhary, learned senior counsel, assisted by Mr. So-and-so, appears for respondents
1 and 2.
1 and 2. Is there any interim order?
No.
No, no, lordship.
Let the matter be listed for hearing in the month beginning from May.
May. Date, you may indicate the
Lordship,
date.
lordship, if we may kindly have this within the month of March, lordship. Because we have been waiting for quite a long time to receive our the relief claim in this writ appeal, lordship. And considering this matter is from ISO, lordship.
We'll have it in end of April,
Lordship.
27th.
27th April.
Lordship.
Is list for hearing on 27th April.
Obliged.
The number 45.
May I please, your lordship? Yeah, I have a combination of delay, your lordship.
Family court.
Diverse application has been allowed. You have to admit.
नहीं तो this is a delay will have to be done.
There's a delay. The notice will go to the other side of the delay conversion application.
Heard
Yes, Nazreen.
S. Nasreen, learned counsel for the applicant. Let notice be issued returnable 4 weeks. Steps on the opposite party be taken by the applicant within 4 working days from today by registered post. List after 4 weeks.
Matter number 46.
My lord, in this matter today, we are seeking adjournment, my lord. The concerned counsel, my lord.
Eviction notice. भी आपके साथ ही बैठ के कर लेंगे
My lord,
क्लासिफिकेशन
my lord, in this matter, I'm seeking adjournment today. The concerned counsel, my lord, has fallen sick this morning, my lord, so he could not come. On his behalf, my lord, I'm just making.
It was a delay petition, we'll just, we should have noticed,
I have not.
but you are not there.
I'm not there, my lord.
The request of Mr. Ardhar, matter be adjourned for a week.
My lord,
Next week,
next week, my lord.
next week, as the learned counsel appearing for the applicant is indisposed. MSD goes for
Caveat, your lordship.
the caveat.
My lord,
I have not been served with a copy of the IA.
I will inform my lord.
copy
Copy of the IA be furnished to the learned counsel appearing for the respondent.
today.
My lord, a date may fix, my lord.
Yes.
A date may fix next week, my lord.
Give a date next week. 9th,
My lord,
10th.
my lord.
Yes,
Friday.
Please.
I don't think we will be able to take up the hearing matter. We may call them if anyone is there. Any more matters? Call out. Let's see.
Matter number 47 for hearing.
Maybe some might have come in purchasing.
Yeah.
Rejection of bid. This might have become in purchasing. Known to the client. Has there been a fresh tender process in the meantime?
It is 2016 matter. I think it is in fact has become now.
Call the council
Yes, Lord, at 2 p.m.
2 p.m.
Matter number 48.
I'm not the respondent. Okay, I'm paying for password a matter for time being, your lordship. Lordship is a central access appeal, lordship. For timing at after 2 o'clock, lordship. The other matters are fixed at 2, lordship. Lordship,
It was rejected on the ground of delay. And Lordship has already decided in Lakwati state. Lordship.
My senior would like to place some other judgments also, lordship.
Next month.
We'll have it next. But they'll have to argue. We'll have it next.
In April.
As per convenience of this.
April.
Lordship, as per convenience.
11th April.
April.
11th April, lordship. Much obliged.
List this matters for hearing in 11th April.
Matter number 49.
But see, 49 is almost similar matter where their claim was rejected on ground of delay. So my also we can maybe taken up both the matter may be taken up together.
You see 11th April.
Lots.
Matter number 50 to 52.
In these cases, Lordship, out of the same judgment, some other appellants has preferred an appeal. It was also already disposed of by this honorable court.
Those appeals have been disposed of.
Disposed of.
Then we have the order.
I have the order, Lord.
Please show.
It is gone against the appellant. Lordship.
It has gone against the appellants.
Out of the same judgment, Lord. Same judgment.
What do you say?
Okay, may I pray that marriage password time being lordship. Senior will appeal.
If the same judgment has been affirmed by division bench.
Lordship, I need to concur with you also.
Okay, 2 o'clock. Password.
Matter number 54.
Wait, please, my lord. My lord, the Carnatic Council, Mr. NJ Petitioner is in legs on court number 18, my lords. So I pray before my lords to pass over the matter for the time being, my lord.
Lordship, matter may pass over for the day, lordship.
As prayed, list after 2 weeks.
Deeply obliged.
Matter number 56 to 58.
Wait, please, your worship. The union is in appeal against an order passed by the learned single judge where on delay of payment to be made on transport subsidy, the interest of 12% was imposed. Worship, I do find that there is a division bench judgment in my senior friend's favor. But just now I've been informed, Lordship, by my predecessor in office that an issue is pending before the Supreme Court. If I can get it clarified, Lordship, if it can be taken up next week, Lordship, I'll get it clarified. Otherwise, Lordship, there is a division bench judgment in his favor, Lordship.
No, you make a statement whether any such similar controversy is pending before Supreme Court, well and good. Otherwise, we'll dispose of this appeal in light of the judgment.
Yes, Lordship, that I.
In fact, my lord, Supreme Court, my lord, I think there is no.
I do not just, Mr. Kriya informed me, so
Only
I just wanted to
my lord, already.
You can come back on second with the statement.
second Lordship,
14.
let it be on 14.
What is the judgment?
This one, my senior friends, that is J. Tarian versus, sorry, Union of India versus J. Tarian.
No, my lord, thereafter, my lord,
That-
the other judgment is there, my lord, that. Issue
Yes.
products here,
All-
judgment. has
All
been
relied
passed, my lord.
upon this.
In fact, my lord, what happened in this case, my lord, only issue was.
Where I was a part of the bench.
Lordship,
Yes, my
I
lord.
think that matter is pending, perhaps, subject to correction.
Then we'll have to wait for the outcome of the SLP.
Yes, but in fact, my lordship may kindly bear with me, my lord, for 2 minutes. In fact, my lord, in they have filed the case, my lord, matter is not subject, my lord, only thing is that only they filed the case, but once the case is already been disposed of, perhaps, my lord, it's up to your lordship, so lordship, my next week.
So we'll give them liberty to go to Supreme Court in this matter also. You want us to do that?
Issue, my lord, is finally be covered, my lord, that's why I told you.
Yes, wait for the outcome of the SLP. Status quo is ordered. Then of course we can't proceed, sir. It's the statement coming from a council that status quo is ordered, then
If you have the details, you can pass it on, we'll record it.
My lord, may.
then we'll have to defer it to awaiting outcome of the SLP. If there is a status quo by Honorable Supreme Court, we can't decide the matter here now.
By relying on the judgment.
May I submit, my lord, the subject lordship convenes, my lord, if the matter comes up next week, my lord, we can also take it up, my lord.
We will keep the matters on 14th April. In the meantime, you please provide the copies. 14th April as per. 14 March.
Much better.
Item number 59.
May it please your lordships. One of the Indian Oil Corporation is your lordship, attending an order of the Honorable Single Judge by which the writ petition was allowed. It is regarding a retail outlet, petrol pump. And the dealership was terminated on 2 findings. Finding of unauthorized fitting in the dispensing unit. And it was terminated, and that termination order has been set aside by the Honorable Single Judge. Now, my lord, our contention before the Honorable Single Judge and before lordship is that, my lord, all the procedures that have been laid down under the guidelines of the Indian Oil Corporation that were followed, and the writ petition was given all the opportunities of defending her case. And thereafter, my lord, the decision was taken by a speaking reasoned order.
Totalizer sealing.
Yes, my lord.
We'll pass the matter over. You'll find out a judgment of Rajasthan High Court in 2023 on the same issue. That is in favor of the corporation. Precisely.
23, madam.
23. So rather, we'll provide you the judgment at 2.
I'm grateful, madam.
We interfered in the single bench judgment, almost on the same controversy.
Here my lord, the interesting part is my lord, the totalizer unit, my lord, when it dispenses, they have a can wherein, my lord, a particular level is fixed. 5 liters, say. 5 liters, no issue. They say that now there is an extra shaft put there. That shaft has to be operated from outside by a screwdriver. You will have to lift it. My lord, this is what won favor with the Honorable.
Just wait for a while, sir.
Lordship,
Get the judgment.
Lordship,
and
we
share
are
it with you.
2 o'clock I'll have.
2 o'clock.
Lordship.
All right.
Item number 60 to 62.
Well, in this case, my lord, I'm led by Senior Counsel Ken. So can it be taken up at 2 p.m. my lord?
2 p.m. Pass over.
Like.
Item number 63.
May please your lordship, kindly matter may be passed over for time being. My lord.
What is it matter about?
Yes, I am challenging this judgment passed by the under single judge, your lordship, whereby he was given the compulsory retirement, your lord.
Okay.
Yes, your lord.
This,
Disciplinary proceedings, your lord.
you want the matter to be taken up today?
As convenient, your lordship, because your lordship is rising earlier, I suppose.
We have a reference.
Yes, your lordship.
So, well, you take a date, probably in the April. Date दे दीजिए. Can have it on 11th April,
Oblige, your lordship.
as jointly prayed list on 11th April.
Much obliged, your lord.
Must oblige.
Item number 64.
May the lordships. The instant PIL has been filed seeking compensation for prisoners who are victims of crimes within the jails, those who are convicted and inside prisons, and thereafter have been subjected to some crime and have died inside the prison, your lordships. Now, on the last occasion, if your lordships would note, the honorable court had been pleased to direct the respondents to file an affidavit whereby, as per their records, how many deaths have happened inside the jails, which are in those crimes.
Unnatural deaths.
Your lordships. Now, to that affidavit, as per their specifications, that is running page. I'm talking about, the affidavit starts at page 419, and the annexure 1 of that affidavit is at page 422 of your lordship's file.
Two.
422, annexure 1 of that affidavit, which has been filed by the learned respondents. Now, your lordships will find, as per them, only 3 convicts, serial numbers 4, 5, and 6 have died.
Head injury, suicide.
Yes, your
cut
lordship.
neck.
Yes, as per them. Now, the earlier 3 cases, I have demonstrated by way of my affidavit, which I have filed subsequently on 24th of January 2023. I have shown how the other persons have also, in fact, died of crimes which are unnatural deaths, which can be categorized as unnatural deaths. Now, lordships will kindly take up my affidavit for a moment. Lordship, there's a convenience compilation that I have filed for your lordship's convenience. If your lordship will take that up, that would be convenient for your lordships to refer to all the documents, because the pleadings are somewhat voluminous. So therefore, your lordships.
Yes.
Now, let me start from the beginning, your lordships, as to what exactly is an unnatural death. That has been defined by the NCRB. If your lordships will come to page 1 of this compilation, there are the first few pages A, B, C, D, E. If your lordships would leave that and then come to page 1 of this compilation, your lordships will find that the NCRB, that's the National Crime Records Bureau, has defined unnatural deaths at page 3. I am taking up the typed copy, lordships. Unnatural deaths include suicide, murder by inmates, death due to assault by outside elements, death due to firing, death due to negligence, or excesses by jail personnel, etc. Besides, accidental deaths inside prison has also been added under the category of unnatural deaths. Lordships. Further, on this right-hand side column, the suicide under the category unnatural deaths has been further subcategorized into the following modes: hanging, poisoning, self-inflicted injury, drug overdose, electrocution, and others. Now, so there's no dispute on the fact that unnatural deaths has been categorically defined, lordships. Now, the second aspect of the matter is exactly who is a victim. Now, victim, lordships, are aware that under section 357A of the CRPC, that victim has been defined and a compensation scheme has also been framed by several state governments. Thereafter, your lordships are also aware that in 2017, in the matter of in-ray prisons, the Honorable Apex Court has let's say, broadened the definition of a victim, and has also said that a person who suffers an unnatural death inside a prison is also a victim. That has been held in paragraph 55 of that particular judgment, your lordships. Now, the third aspect is that if that definition has now been defined, as per the Criminal Procedure Code, under section 176, once an unnatural death has occurred, or any death, inquest report and a magisterial inquiry report thereafter is required, Your Lordships. Now, as per the magisterial inquiry report, what has happened in these particular matters, the guidelines for the magisterial inquiry report have been very categorically laid down by the Human Rights Commission. Those also I have annexed in this compilation, Your Lordships. Now, initially, when we had filed this PIL, it was to espouse the cause of only one particular one particular inmate. However, by virtue of judicial orders, the scope and ambit of this PIL was broadened, and the Honorable Court decided to take up the matter on an entire state basis. Thereafter, the learned counsels for the respondents were directed to produce all the entire documents, by way of which we are now at least in session of certain documents, Your Lordships. I have made a chart on this convenience compilation at page 6. If Your Lordship will just take up that chart. Now, these are the cases which have come out from the various pleadings which have been produced before this Honorable Court. The first person is Manik Ali, who died in Nagaon. Your Lordships will find the inquest report have been annexed. I have also annexed the entire inquest reports and everything in this compilation as well, Your Lordships. Now, they have admitted to his being an unnatural death by affidavit dated 22/12/2022. So I will skip this. The second is Abdul Mannan. Now, insofar as Abdul Mannan is concerned, if Your Lordships will go to that affidavit, which I was just referring to, my learned friend's affidavit of 22/12/2022. Here, in the case of Abdul Mannan, they have said that they have decided he's at serial number 3 at page 422, Your Lordships.
Yes.
Yeah. And they have categorized him as natural as per postmortem report. Now, the previous column of that same chart, Your Lordships, the cause of death.
Not a certain.
Not a certain, Your Lordships. So if that is the case, then how can they say that it is a natural death if they have not even ascertained the cause of death? And in most of the cases, Your Lordship, what has happened is that magisterial inquiry reports are being conducted I apologize for saying so.
We have the postmortem reports available.
Of some of the victims they have provided, but of not, there are 29 that we have identified. If Your Lordship will take up my affidavit of 24/1/2023, the last affidavit before Your Lordships, that is running page for the last page, Your Lordship, 437 and 438.
Yes.
Now, these we have found out by way of the documents which have been produced by the learned state council, that these are the incumbents who have died unnatural deaths. And Annexure B.
Mr. Saikia, are you having the medical records of all these prisoners?
We have number one, and last time they have filed an application, affidavit. Yesterday, I have received another detailed bunch of papers from them. I would like to file that on record also.
We like to have the postmortem reports or the medical reports.
Yes, Lordship, we have everything.
We'll just like to
Absolutely, Lord.
look at those.
Yes.
And you can provide a copy.
Yes, we'll
This
process.
is a public cause, plain and
No,
simple.
no difficulty, Lordship. Absolutely,
So
Lord.
please do that.
Yes, Lord.
Then Advocate General.
1 week time may be given. to
Place
file.
on record. The summary of medical records of all prisoners, all 29 prisoners referred to in the additional affidavit filed on behalf of the petitioner, dated so and so.
24/1/23.
List on 14th.
14th of March, Lordship.
Yes.
Deeply obliged.
Highly obliged.
Letter number 65.
My lord, this matter has been longer listed today, my lord. It is fixed on 28/3.
28/3.
Order, last order, it's at
Check. 28/3.
28/3.
28/3. Last order 8/2.
Order sheet says 28/2. You want it to be taken up on 28th March.
Lordship,
We
can it
don't
be
have any
30th,
difficulty.
38/3. On 38/3, Your Lordship.
30th March.
Yes, Your Lordship.
So as jointly prayed, list on 30th March.
Hold on, lord.
Letter number 66.
May it please, Your Lordship.
Lordship, this matter relates to a removal of a Gaon Panchayat president by way of a no confidence motion, your Lordship. And we are agreed by the order of the learned single judge below, your Lordship. Now, this appellant, your Lordship, he was the elected Gaon Panchayat president. And your Lordship, and he had taken charge way back in 2020, your Lordship, and in 7/1/2021, immediately after taking of the charge, your Lordship, he had some differences with the secretary, and he made a representation to the government that the secretary may be changed because he is not cooperating in doing the system. So thereafter, your Lordship, this secretary in connivance with some GP members, ward members, they have filed a requisition at page number 25, Annexure 3, your Lordship, on 22/1/2021, seeking to bring a no confidence motion against the present appellant, your Lordship. Now, as per Assam Panchayat Act, your Lordship, once a requisition is filed, that has to be placed before the president, and the president gets 15 days time to decide for a no confidence motion. If it does not take any action, thereafter the matter traverses to the Anchalik Panchayat. So the act prescribes a time period. But the secretary, without informing this president, your Lordship, the appellant, he referred the matter to the Anchalik Panchayat, your Lordship, after about 23 days. And the Anchalik Panchayat convened for a meeting. On getting the information, your Lordship, the president, he also appeared in the no confidence motion that was held on, your Lordship, 22/2/2021. And in that meeting, your Lordship, after going there, all the ward members have been asked that you put your signature in the ballot papers. They put the signature on the ballot papers, blank ballot papers. And thereafter, your Lordship, since majority of the members voted against the no confidence motion, in fact, the no confidence motion was lost. So thereafter, he was continuing to discharge his duties. After about 1 month, your Lordship, the impugned order was issued at page number 28, your Lordship, saying that the vice president has been given the charge as a no confidence motion has been passed against him.
Has been passed.
Passed. Issued by the deputy commissioner, your Lordship, at page 28.
Where is the record pertaining to the no confidence?
Yes, proceeding, your Lordship, at page number 40.
40.
40.
Yes. You say that it was dropped,
Yes, your Lordship.
or rather it failed.
Failed, your
How
Lordship.
do you say?
Because, your Lordship, in this, on that day, he was also present there, your Lordship.
Yes.
And the members were also 8 members participated, your Lordship. And out of them, 6 members voted against, your Lordship. But the resolution contains a different factual story, your Lordship.
Where is the resolution? Read.
Lordship. At page 48 starts, your Lordship. Page 41. May I read, your Lordship?
Now, after counting totally 8 numbers of vote casted in favor of the motion and against the motion is 0, and 1 ballot paper was cancelled.
Lordship.
So it is a passed motion.
Now, this, your Lordship, I have challenged it before the Honorable Single Judge, your Lordship. Now, the single judge, without issuing notice, he brought forth the record only to ascertain whether the no confidence requisition was placed before me or not. Now, the record is with the secretary.
So you see, requisition being placed and the statement you make that the no confidence motion was actually dropped, but it was lost. How do you say that?
Because, your Lordship, thereafter, in this case, your Lordship, after filing of the appeal, your Lordship has issued notice, and 6 members, ward members have filed affidavit stating that they have not supported the motion.
That is a subsequent change in stand. That can't be accounted for. Whether there is any statutory remedy against a no confidence motion being passed under the act, there must be one statute, Panchayat Act, there must be.
Now, the fact is that, your Lordship, these 6 members, now they have come and they are saying that.
We are not here holding a de novo trial.
No, my limited prayer, your Lordship.
Yes.
Since the no confidence motion was there, let the matter be, let a no confidence motion be held, your Lordship.
Why?
Section 15. Because earlier no confidence.
Section 15, my lord.
Section 15 is the.
15.
Yes, ma'am.
Because since these are factual things, your Lordship, therefore.
So there is no question of interfering in a writ jurisdiction.
There is.
These are purely factual disputes, sir.
Yes.
Now you say that 6 have opted in your favor. whether this is a subject matter of writ jurisdiction.
No, your lordship, these are factual, but on the basis of these facts, the resolution had to be passed. Now, if this member said that, no, we have not given,
But that is a change, that is a witness turning hostile after deposing in court.
that is not so. And secondly, your lordship, there are some, the voting has to be done in a secret ballot mode. Now, what happened? They have taken the signature of these persons in blank papers, and then they have.
Is your allegation, what is the material to support this allegation?
No,
Subsequent affidavit of the 6 persons can't be considered.
because these are the affidavits, they are stating on affidavits, your lordship, that they have not.
How was the voting? Secret, my lord, the resolution itself is saying, my lord.
Resolution deeds.
Resolution is, yes, my lord.
We have to rely upon the resolution.
No, if the signature is taken on the ballot paper,
Only
your lordship,
after
it
passing the
cannot.
resolution, my lord.
All a factual dispute you are entering into.
No,
Yes, my lord.
lordship, if the signature of the candidate is taken on the ballot paper, it cannot be a secret ballot, your lordship.
Why?
They have taken on every secret in ballot paper, they have taken signature of the person. You sign and you then give a vote to whom you are giving. So
Then what are they supposed to do? How is the ballot paper to be casted?
the ballot paper has to be given, it has to be given that yes, I support or I don't support, your lordship.
Yes.
But in fact, after giving the
So
ballot,
how would the punch acknowledge the ballot paper? By signing against the name in favor or against?
in a separate register, they may take up, your lordship, but in the ballot paper itself, they have taken the signatures. This is my fact, this is my pleaded case, your lordship. In
All right.
blank ballot paper, your lordship, they have taken signature and it was not at all a secret ballot, your lordship. And in fact, the majority members did not support the no confidence motion also. And
Very
the
well, sir.
and the consequence is disastrous. Your lordship will see that section 15 consequence is disaster. An elected Panchayat president is removed.
Lordship, allegations are very serious, but no FIR has been filed, my lord.
These learned single judges recorded a finding that you
Lordship.
refused to accept the that notice.
That is one part of the there
Then
because the GP secretary
you
maintains
yours
the records.
you submitted that without informing you, it was sent to the Anchalik Panchayat.
Lordship.
But the record says otherwise.
Refusal.
That is because the secretary is the custodian of the record and he has produced the record. Since there is a dispute
One-
between me and the secretary, he has taken up this thing like
Yes,
this.
sir.
Lordship.
One more aspect, my
Issues are
lord.
disputed, severe disputed
So,
questions
my
of
lord,
facts.
Very
going to
limited prayer, your lordship. Let the no confidence motion be tested, your lordship.
No,
Because
need
since
to
the
do. It
majority
has already
members are,
been done.
since the majority
There
members.
can't be another one for 6 months.
And lordship, admittedly, he was present in the meeting, my lord. As per Apex Court order, Padmini Sinha judgment, my lord. He waived his right, my lord. He also admit that, my lord.
Heard, dismissed.
Highly obliged.
That's true. You don't try to put us in the same situation. SLP against? So the SLP has also been dismissed. So then the fate is accomplished now. Then probably you have to file a recrimination application before Supreme Court. Against? Yes. Yes. So this appeal was dismissed on delay. But hearing the decision of division bench affirming the judgment of single bench dated 1st February 2018 is on merits. That appeal was against a different judgment. What you are referring to tomorrow. Tomorrow. Tomorrow.
List tomorrow as requested, jointly requested.
Item number 59,
Kanta Garasia. Yes. Try to distinguish this. Wait. This is 22 judgment. I was under the misconception that it's 23. 30th September, yes. So when do you want, sir? You have a copy of the judgment? So the moment the word totalizer was referred to, I recollected that we had decided on. So as jointly paid list on 14 March. But ultimately that Gujarat High Court judgment, that would be the one which you will have to distinguish.
Matter number 60 to 62.
What about the others? Okay. Okay. Oh. Okay. So would you be needing instructions whether to continue the Mhm. Okay. Don't assume all knowledge with the court. There's no such presumption. You can very well say that you are trying to put some information into our mind. Yes. Right. Mhm. Okay. This appeal. This is against the Mhm.
Whereas under the great pay, my lord, and some page 145.
Are we undertaking this academic exercise for any purpose today? The other side. We understand, but all the parties are not there. You are only in one case, and maybe he has lost interest also.
Yes, it can. Supposing that case, whether my lord, here, and the party here.
Okay. You just take your instructions. We can post the matter again on a hearing day, maybe 21st of March. If not, then in May. April, we want to keep ourselves little free for the. So we'll have it
Can I pay on
9th May,
9th of
March, very well. Sure. As jointly prayed, list on 9th March.
Item number 67.
Adjournment slip. An adjournment. An adjournment slip has been circulated by appellant's counsel. The other side has no objection. List. Respondent counsel. The respondent counsel has circulated a slip. 67. 67. List. In May. For hearing in May. 68.
Item number 68.
Yeah.
Okay. Have you been given opportunity to rectify the error?
For example, my lord, is not taken ground. And my lord, when close because each and every point here, right? How to say this habit is not intelligible. But all that is required is some evidence.
Not beyond reasonable doubt. That's true. That's true.
Some evidence is there, there is the end of it. Otherwise, my lord, if there are any- there is perfect-
Yes.
And so my lord, the honest is that the order. Okay, at page number 309.
Paragraph.
Paragraph.
Yes. So this writ was filed after final order was passed on the inquiry. And the writ was directly filed. Is there no mechanism for appeal or anything? So this is against, writ was entered in against an appellate order.
I just want to go my God, I feel like- Can I come to take one bit? Thank you.
No. You don't know. Yes. Yes. 123.
This is the reply by the I got the infant in the article of Parliament. In the start, article of
Any such indication that the delinquent was not able to understand the consequences of charge? Yes.
And my lord, item number 2 was not true, therefore I not up to the part. This was my first booking at the
Can we have the memo of appeal? Yes.
Page 79.
Please read from that memo whether there is any pleading regarding the charges not being intelligible.
169.
Yes.
This is inform you that I'd like to point out here only
Is not what is the fee that the charges a delinquent because that the charges intelligible. So that is because the delinquent is the fee. What is that I am not able to understand the consequences of it. Unless we take the to accept this. Yes. He has tried to explain every finding and every charge.
and in the petition also there is no.
Read, please. Please read.
Yes.
Page 36. Yes. Page 63. What about the fact that no such averment is there in your departmental appeal? Sir, you are supposed, if you are not able to understand the charges, this statement should have come at the first instance when you filed a reply to the articles of charges. Even in appeal. Let us see. Let us see. Not a matter of not protesting. Let us see your pleading first in the writ petition.
My lord, there is one sentence. Further effort to take the case, hence the entire proceeding allowed in doctor. How it is based on the take? Take assertion is not true. You got the opposite. If you are allowed because in a proceeding, things have a lot of importance.
They have definitely.
1988 there is a difference between things playing that.
Yes.
Here, my lord, you must take out.
You are proceeding on affidavit. Yes.
This is my lord absolutely vague. That is an absolutely vague. My lord. Then the week of the charge of guarantee is something like 10 and 13 here is the lord. He has answered everything. Therefore, say that he was presented by the basis of the charge. That ground is something. In 150, in the memo version, there is no ground. In
Any judgment on this issue? On what you are arguing regarding vagueness of charges? They will have to point out the judgment in their support. But do you rely upon any judgment in support of your contentions that unless these averments are made in the appeal or in reply to the article of charges, this plea cannot be permitted to be taken in 2 to 6? No, if it is a legal issue, it can be raised at any stage, no difficulty. But this is a factual issue, plain and simple. So taking it for the first time in the writ court, not taking it in 2 forums before that, whether we'll entertain such a plea. Mhm. Mhm. All we can garner from this is that you've got a phenomenal memory. Yes. Naturally. You see, this is an issue whether the man was able to understand the consequences of charge. If it doesn't say so before the and even the ground which has been raised is simply saying vague, standard kind of pleading. Yes. Let us please read the findings of the single bench again. Hmm. So this was virtually an admission on your part. Hmm. But in view of this case of this admission. But why you admitted it before single bench, sir? The court was able to persuade the council to make the admission. Then we'll have to wait for another day, sir. We'll hear it extensively. Uh, Please do that. We will see, sir. You'll get the opportunity to. Appreciated. All right, sir, we'll hear you. As jointly prayed, list on 9th May. Interim order shall continue. April, sir, we are trying to celebrate the platinum jubilee of this court. So bear with us for a while. 9th May. You can have any earlier day on May. 3rd May is okay. 2nd May rather, Tuesday. Not required, not required. Don't worry. We are calling out each and every hearing matter as dictated by Mr. Chaudhary. No, it's just on in the lighter vein, sir. That had been the trend. Even in Rajasthan, every hearing matter was called out, at least in my court. Thank you. Thank you for the certificate. No, it's, we'll hear you. Don't worry, that is for, that we have gained something out of the time we